Why don't you go see your boyfriend?
Yeah, he got a nice room. He won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen to a funny.
Oh wow, testing 1, 2, 3. Is this thing on? It has been a minute and I'm unmuted. Thank goodness. I was worried I didn't even know how to use StreamYard anymore because it's been a little while and I am a married woman, a married woman. Can you believe it? Also, Lisa, I hope that you landed up coming back. Lisa was on at 12:15, so 6 hours ago. Hey, Lilith and Adam. Oh, come on, click, click. Do the thing. You can do it. And Adam Fignally. Yeah, Broken Baker, I got demonetized for alleged reuse. Took them on and won. So now once we figure out how I can get post, all good. Yay! Lisa is back. Mom is here. Steve, I'm so glad as well, Lilith and Steve, that it remembered your memberships because we were worried the first time that it wasn't going to show. The reason I moved the time of the live is because I was busy trying to get this court, a thing from this court, but it wasn't as exciting as I thought. And then now, when I came back, it looks like something is happening. So while we let people join, let's have a watch here. Just find my spot. I heard the judge telling someone off.
Okay, calling case 19-004107 in the matter of Matthew James Buds. Counsel appears for the record.
Nancy Plaster for purposes of arraignment only on behalf of Mr. Buds. I've advised him of the charge as well as his rights. He's going to waive formal reading, stand mute, ask for a plea of not guilty. We're asking that the bench warrant be set aside.
Court will enter a plea of not guilty on your client's behalf. Court will set aside the bench warrant. Sir, at the jail, state your name for the record.
Matthew James Buds.
Okay, counsel, this matter dates back to 2019. Your defendant has been missing since then, so you may proceed to address bond.
Yeah, this is actually a disturbing piece out of the Novi District Court. It looks like Mr. Buds has already resolved this matter, but didn't appear for sentencing or respectfully.
It was set for a bond violation hearing back in October of last year, and the defendant looks like he failed to appear call, he called and stated he couldn't make it. He failed to appear. You may continue, counsel, addressing bond.
That's all right. I'm told that he is employed for a tree service. Respectfully, we're asking that you consider a lower bond than what was set at 5,000. Well, I'm not really even, it looks like he did a paid partial bond, which is kind of not sure if he might have posted this bond at some point, but respectively asking for lower than a 5,000 cash surety, 10%.
That bond got posted.
Well, then,
Okay, so like I've indicated, Mr. Buds, state your full name, Mr. Buds.
Matthew James Buds.
Okay, like I've indicated,
Okay, I'm sorry to interrupt so soon, but this is funny. Lilith gifted a membership and it went to Evie, the mod. It always breaks my brain that mods have to have memberships. It's so weird to me. Anyway, thank you, Lilith, and welcome, Evie.
back October 18th, you were scheduled to appear for a bond violation hearing. You called the court and says, I can't make it. And they haven't heard from you since. So I just want you to be aware of that.
Yes.
That's what you said.
I
Okay,
called-
let me
Right.
go ahead.
So yes, I called and I told them I couldn't get a ride because I didn't have anybody that was gonna give me a ride at the moment. And I think I had two things going on. I had to be, at the time I had to go drop. At the same time, I had to appear in court. So it's either or, I was gonna violate something. So I had to go
So-
drop or
Okay.
show up at court. So I had two things running together at the same time.
Okay, well, you need to come to court on this because you said you couldn't make it that day, but you never contacted the court again. So give me a second.
Okay,
He couldn't get a ride
Matter
in
of fact, I set the
2019.
bond on you back for 5,000, cash surety 10%. I set that bond earlier on you. Well, I'm gonna set a $200 cash surety bond. No 10%. You need $200 to post. You gotta make sure you show up to court because you failing to appear in court when you're supposed to. It's on an original disturbing matter. So I'll set 200 cash surety bond on this matter. I do have some other conditions for you. Just make sure you personally appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You must contact the 52-1 Bond Compliance Unit here at the 52-1 District Court in Novi on Monday, December 2nd, and pick up no new criminal offenses while you're out on bond. This matter is going to be scheduled for a bond violation hearing based on your inability to show up to court back in October of 2023. This matter has been going on since 2019, and it just needs to be resolved. All your previous bond conditions remain. Yeah, you understand your bond conditions in this file, sir?
yes,
Okay, you're all set. Good luck to you. You can walk out the back. They'll let you out, okay? Good luck to you.
okay.
right.
Can I mention one more thing?
It's up to your attorney.
he's already set the bond, sir. Just make sure you contact the court if you get released, okay?
Yeah, I just can't get a hold of anybody in my family. I don't have any numbers.
You can ask for someone to help you, the depths.
Okay. Thank you.
You have to get back in there and finish your paperwork.
So he couldn't get a ride in 2019. And he's surprised to be here in 2024. Also, yes, there is court on Black Friday because this is like a weekend court. I generally watch it on Saturdays and Sundays, but it's a little bit of like a hurry up and wait court. There's a lot of gaps, so I don't stream it live often. I'll just keep tabs on it.
You're good, just let us check.
I don't want to hit you.
At the jail, sir, what is your name?
Miles Lee Fernie Jr.
What did he indicate, counsel?
Fernie, F-U-R-N-E-Y, Your Honor.
Okay. Okay, calling case 24-004995 in the matter of Miles Lee Fernie. Counsel appearance for the record.
Nancy Plaster for purposes of arraignment only on behalf of Mr. Fernie. I advised him of the charges as well as his rights. He's going to wait for reading, stand mute, ask for a plea of not guilty. It looks like well, I'll advocate at the appropriate time, Your Honor. Please
Okay,
ask.
I'll indicate a plea of not guilty on your client's behalf. I see he's requesting court-appointed counsel. That has in fact been granted in this matter. Sir, state your name for the record.
Miles Lee Fernie Jr.
Okay, counsel, would you like to address bond in this matter?
Your Honor, this matter is, well, my client has been working out some issues with homelessness, Your Honor. However, at this time, I believe he has an address that he can provide to the court. I think he might be a little bit more stable. Respectfully asking that you consider a lower cash surety 10% bond in this matter.
Was an original bond issued by the court September 2024. That would have been September 5th of this year. Bond was in the amount of $750, but the defendant failed to appear in court. Sir, you're no longer at the Dixie address, apartment
No,
7?
No, sir.
Where are you going to be living? You have an address? You're going to be living somewhere?
My mother's
What is that?
house in Waterford.
You have the address?
I don't know our address, sir. It's the,
Okay. That's all right.
it's the
understand.
apartments.
That's okay.
I've been
All right.
doing,
So
I'm sorry.
that's okay. I understand you have trouble with the address. That's not a problem. I'm sure you'll get it at some point in time. So because the court's going to need a place to send your mail. So the bond was already set by the judge. I'm going to leave the bond set, $750 cash surety, no 10%. I do have some other conditions for you, sir, that I want you to be aware of in this matter. You must personally appear for all court proceedings. Do not leave the state of Michigan without permission of the court. Immediately notify the court in writing if you should change your address or phone number. I'm going to make a note here. It's going to say provide the court with a valid address within 24 hours of your release. Since you do not have a valid address, we have no idea where to send any mail to you notifying you of any court dates. So I'm going to put that down within 24 hours of release. You need to find out what the address is so you'll know where you're staying and will know where you're going to be.
I won't be able to postpone, sir. I have no way of postponing.
Okay, let me finish. I've got a little bit more to go over.
I'm sorry, sir.
So yeah, no problem at all. So just make sure you show up to all your court dates. Do not leave the state of Michigan without permission of the court. We already talked about your address. Provide the court address within 24 hours of your release. You will not possess any firearms or other dangerous weapons. You're going to be required to test 2 times a week for alcohol and drugs. And you must contact pretrial services Monday, December the 2nd. And you're gonna have to contact them just to find out what your court date is if you're released too, because we don't know when to send an email to you. Pick up no new criminal offenses while you're out on bond. Now, do you understand what I read off to you, your bond conditions?
Yes, sir.
Okay, you're all set. You can just walk out the back. They'll let you out at this point, and good luck to you.
All done?
At the jail, what is your name?
Ashanti Nash.
Give me a moment, counsel. This is my file I want to. Yeah, we'll get to it in 1 second here. I've got a few things down already.
Another court's just come on with arraignments. But I want to see if there's anything interesting here. Donald, this makes a lot of sense because it's always like pretty random, like chilled things. Sometimes there's like suburban Karen-y-esque hearings, but for the most part, like one of the reasons I just have it on in the background is I just skim through it and see if there's anything super interesting, but often it's pretty chilled.
Well, it looks like we have 6 files here. Most are driving on a suspended license, registration plate violation, and failed to answer a summons. These cases go back to 2018, 2020, 2022, and 2023. So it's a continuous issue here. Let me call these particular cases one at a time. Calling case Charles Knorr, 20-000912. Ashanti Nash, counsel appearance for the record.
Nancy Plaster for purpose of arraignment on behalf of Ms. Nash on all of these matters.
Okay.
She's gonna waive
Ms.
formal,
Nash? Okay, go ahead, counsel, sorry.
reading, stand mute, ask for pleas of not guilty on these matters, Your Honor.
Okay, court will render plea of not guilty on your client's behalf. Court-appointed counsel is also granted on these files as well, counsel. Ma'am, at the jail, would you please state your name for the record?
Ashanti Nash.
Hold up, we're going to the other one. I just read some of the subtitles and was like, oh, that's where we're going. This is Reno Municipal Court. No, yes, Reno Justice
I don't
Court.
believe we need you today.
All right, perfect. Have a good weekend.
Thank you, you too.
Bye-bye.
We have everybody else with us?
Yep.
All right, Mr. Merritt, you can hear us, and Mr. Reichenberg, you can hear us?
Yes, we can hear you from the jail.
Yes, Your Honor. Thank you.
Clerk will call the first case.
First case is the state of Nevada versus Eric Carreno.
Mr. Carreno, I've decided there's probable cause to warrant your arrest and detention. I've assigned the public defender to represent you. Score 14 on the NPRA and score 1 in the failure to appear category. This is the lewdness charge and related matters. Mr. Reichenberg, I'll start. Mr. Merritt, are you going to be asking for bail hearings in all these cases today?
That is correct.
All right, Mr. Reichenberg, then we'll start with you and Mr. Carreno.
Yes, Your Honor. And Mr. Carreno, we're asking for $5,000 bondable bail. Your Honor, in this case, the allegations as far as open and gross, frankly, quite egregious in the fact that he slipped his cuffs and exposed himself to an officer and made comments that officer. Defendant also has lengthy and concerning criminal history, primarily for domestic battery. He had in 2018 a misdemeanor domestic battery first conviction in Sparks Municipal Court, one in Elko Justice Court, and then a felony conviction for coercion with threats and misdemeanor conviction for domestic battery second in the 4th JD, so 3 domestic battery convictions in that year. 2020, he had 2 separate domestic battery third convictions in Elko. It looks like they were resolved at the same time. And then he had a misdemeanor conviction for violating a domestic violence TPO in Elko in 2023, as well as an arrest for a failure to appear out of Reno Municipal Court in that year. And then he had an arrest earlier this year for obstructing and resisting in Elko. I believe that forms part of the 2 warrants that he had pending at the time he committed these acts. So again, concerning facts, lengthy history of violence. Appears that most of his contacts, although he has the 18 case in Sparks and the Reno Municipal Court case, which I'm unable to see what that is right now, that he had the failure to appear from, a lot of his contacts are in Elko, so unclear what contacts he has with this area, and therefore, based on his FTAs and those facts, risk not to appear. We would ask that if he were to make bail, that he be tested, they be supervised by DAS and tested for alcohol and controlled substances, as well as that he have no weapons given his prior violence and prohibition on firearms, and GPS ankle monitoring. Thank you.
Okay, Mr. Merritt.
At this time, we'd be asking for an OR on this case with substantially similar conditions that the state was asking for. I think the only deviation we would ask for conditions would be just removing the GPS monitor and the house arrest requirement. While Mr. Carreño's criminal history is concerning, the object offenses in this matter are substantially drug related as compared to the violence he has in his record. I do think that bodes well for the sake of his case and whether or not he could be back in the community. It shows that he's not committing acts of violence as compared to what he had done in the past. In addition to that, he does have 2 holds, one out of Reno Municipal Court and one out of, I believe, Elko, for unrelated matters. With those in mind, it seems as though placing bail in this matter is unnecessary, as he is not going anywhere anytime soon. And so we would ask for an OR in this matter. And if the court is more inclined to keep him in custody, we would also ask for a potential for IAP transport to a residential treatment facility if he seeks out treatment during this time.
I think he's a good candidate for that, Mr. Merritt. It's not just drug. To me, this is not just drug related. We do have the open gross limits / indecent exposure, whatever the state's going to charge with it, obstructing and resisting, whether that be violent or not. For someone that scores a 14 on the NPRA, I'm very concerned with him appearing for court if he is released, and or his, because of the FTA I see, and or his nature for violence with the 14 on the NPRA. So I even think 5,000 may be too low. I'm concerned with this, Mr. Reitman. I do see that there's clear convincing evidence he's a danger to the community and a flight risk, both. He's got holds in other courts, got all kinds of things going on with quite a criminal history. I'm going to make an $8,000 bond or 10% cash. We do have the 10% option, Mr. Merritt. That makes this more than extremely reasonable, even though he may not be able to make it based on his individual characteristics and nature of this offense. I think that's the least restrictive means or alternative I'm willing to consider. There's an $8,000 bondable or 10% cash, recognizing that's more than the state's asking for. I see serious concerns with Mr. how do you pronounce it? Carino? Carino, I think, with Mr. Carino. And so I'm going to also have conditions. I don't need the GPS of the house arrest. I agree with you there, Mr. Merritt, but I'm going to go with check-ins with DES weekly or as determined by them, and no alcohol, no drugs, and testing by urinalysis and or breathalyzer for any evidence of same. I'm not going to go with firearms condition on this either, Mr. Reichenberg. Anything else, Mr. Reichenberg?
No, Your Honor, thank you.
Anything else, Mr. Merritt?
No, Judge.
All right, that'll be it for Mr. Carino. Thank you. Next case, Ms. Clerk.
Next case is the state of Nevada versus Gabriel Gutierrez.
Mr. Gutierrez, I determined there's probable cause to warrant your arrest and detention of assigned the public defender to represent you. This is an ad book matter, and he's already in custody on other charges. He scores an 8 on the NPRA. Ready for bail, Mr. Reichenberg, go ahead.
Yes, Your Honor, thank you. We are asking for $20,000 bondable bail on this case. As the court noted, the defendant had another pending matter, has a NPRA score of 8. He had another arrest back at the beginning of the year for failure to register. It looks like charges were not pursued on one of those, and the other he pled guilty on earlier this year. His underlying offense occurred in 2019, so not terribly long ago. Prior to that, he had a conviction in Reno Municipal Court in 2018 for trespass, as well as in 2017, he had a conviction for obstructing and resisting. And so, taken together, Your Honor, shows a lack of, in addition to the underlying criminal activity concerning for the lack of follow through, the lack of cooperation when he's contacted with law enforcement. I think that shows he's a risk to the community, a risk to not follow conditions and or not show up for further cases. We'd ask for GPS monitoring if he were to be released, as well as supervision by the Department of Alternative Sentencing and the usual obey all laws. Thank you.
Judge, did you want to hear from defense at this time?
Yes, I said Mr. Merritt.
All right, we didn't catch you on this end. My bad.
Yeah, I said Mr. Merritt.
Okay. We would be asking for an OR release at this time with the same conditions that the state has just offered. We do believe that those are fair and appropriate conditions that would maintain the court's goals in releasing someone on pretrial supervision. Looking at his score on the NPRA, he did score an 8, but he did not have record of violent crimes nor of recent FTAs. I think that bodes well in terms of considering whether or not he's a threat to the community, warranting bail, and whether he is supervisable. In addition to that, it is concerning that if we take these allegations facially, that he didn't register at the right place. At the same time, he was readily contactable by law enforcement, and he did provide sufficient information for this charge with law enforcement at their directive. I do think that bodes well in terms of whether or not he can be contacted and ensure that he shows up for later court proceedings. In addition to that, the underlying charge is a status offense. It does not involve any theft, any drugs, any violence. He's not creating a victim out of any specific person in our community. He is only just failing to register if we are to take the allegations as is. We do not believe that it has been substantiated that he's a threat to the community or that he is a threat to not show up for later court proceedings. We do think he is fit for an OR release with the specific conditions that the state has already mentioned. We do think GPS monitoring would be required at this point in time, and we will submit on that.
I think in a lot of ways, the legislature has already intimated that somebody like Mr. Gutierrez is a threat to the community. A registration requirement for an offender, they made these a felony for these type of offenses. They're not misdemeanors like typical ex-felon failure to register or change address. These are much more serious. I think the legislature has recognized that by making the felony. But I agree that this is not the most extreme case of same that I have seen. So I agree with Mr. Merritt on that there's some offset there. But I do find Mr. Gutierrez to be a danger to the community. There's clear convincing evidence of same. I think a modest monetary bail is necessary to make sure he makes all his court appearances and does not reoffend or is more careful with his registration requirements. I'm going to lower the bail from Mr. Reichenberg's request, however. It will be a $10,000 bail, because I do take this very seriously, and I think that's the least restrictive means alternative I'm willing to consider with the following conditions. It will be $10,000 bondable or 10% cash with conditions of checking with TS weekly, at least weekly, or as required by DAS, and I want GPS monitor to be installed upon him prior to any release. Those are the only conditions I'm going to impose. Anything else, Mr. Reichenberg?
No, Your Honor, thank you.
Yes, Mr. Merritt.
No, Judge.
All right, that'll be the order. Thank you. Next case.
State of Nevada versus Carrie Lee.
And defendant Lee have determined there's probable cause of warrant your arrest and intention of assigning the public defender to represent you. Score 10 on the NPRA. We're ready to start sale. Mr. Reichenberg, you're first.
Yes, Your Honor, we're asking for $2,500 laudable bail for Miss Lee.
How much? How much?
2,500.
25? Okay, go ahead.
And Your Honor, so again, concerning NPRA score, she had an arrest back in July for contempt of court. I don't show a disposition for. 2021 conviction for false statement obstructing in the Reno Justice Court as a misdemeanor. Then in 2021, I also show Reno Municipal Court case arrest for trespass. I don't show a disposition for. 2018, another Reno Municipal Court trespass in November, and then a Reno Municipal Court trespass in October of 2018. She had a failure to appear also at that time when she was arrested for the trespass in October of 2018. I believe that was out of an arrest for obstructing an open container from a Reno Municipal Court case. So lengthy criminal history for similar type offenses going back to 2002, kind of a fairly steady pattern of trespass and obstructing and possession of drug paraphernalia type charges going back to that date. And so we believe that she's, and I would note again, it's a trespass was the underlying essentially contact reason. And so concerning for just kind of that Saturn pattern since 2002, we believe that bail is appropriate to ensure that she appears and that she not have any further issues in the community, that she have supervision with testing for alcohol and controlled substances by DAS.
See any evidence of FTAs?
Sorry, Your Honor, let me go back to that. I don't necessarily show any recent history of failures to appear. I show the criminal contempt this year already, which tells me that she wasn't following court conditions. But the most recent failure to appear was back in 2018 in Reno Municipal Court.
Right. I don't see her as a danger to the community, and I'm not sure on the flight risk. I'm leaning more toward no harm, Mr. Merritt. You probably could convince me, but I don't want to see FTCs and contempt and failures to appear. I want her to show up for court. I want her to stop trespassing, obey the laws. But even with a 10, I don't see her as a danger to the community necessarily. So I think I could probably take a chance and OR her here, but you better make all court appearances. Go ahead, Mr. Merritt.
Understood. At this time, we would ask to waive Ms. Lee's appearance and proceed with the bail hearing. We were also going to be asking for an OR release, just in light of the fact that she doesn't pose a threat to the community, even though she did score a 10. There's no felonies or gross misdemeanors. There's no violent crimes. And as the state just touched on, no recent history of FTAs. I think that bodes well. And then just a more nuanced position, the underlying offense alleges trespass from CARES campus, fairly common. They have their own in-house process in which they, I don't know if the right terminology is 86ing, but they have the person leave the vicinity for 72 hours, and then they will generally allow them back unless they specifically ask for a 30-day trespass order. I didn't see one in the factual allegations. And so I think if we do permit Ms. Lee to have an OR release with specific conditions, I think she'll be contactable, reachable, and I think she would be decent on an OR release to make future court proceedings.
Why didn't she here this morning so I can go over this with her?
She just wasn't feeling well. I think physically she was a bit shooken. I don't really know what else with her physical condition was going on, but that was basically the reason.
I don't see this as the most serious of offenses, Mr. Reichenberg. I'm going to dispense with the $2,500 bail amount and simply give her the OR. Well, I don't mind taking a chance on someone that is not, where there's not clear convincing evidence of the danger of the community. There's not clear and convincing evidence she's a flight risk. She may not appear for court, we'll see, but if that's the case, we'll get her on the warrant. She'll stay in custody that much longer. So I'll go ahead and OR her at this time and with conditions of checking with DAS at least weekly, if not more often, as determined by DAS. And I want her to have no drugs, no alcohol. This did have a possession of dangerous drug charge on it also, without a prescription. So I will put the no alcohol, no drugs clause on her. And she must test by urinalysis for breathalyzer as determined by DAS. I'm not sure. We might be setting her up for failure. I'm not sure she's going to do all these things with DAS. We'll find out shortly, I'm sure. The court will give her a next court appearance date for her arraignment. See if she shows up for that and see how she's doing on DAS at that time. Anything else, Mr. Reichenberg?
Oh, no, I think you.
Yeah. All
No, Judge.
right, thank you. Let's go to the next case.
State of Nevada versus Raylan Ojeda.
And defendant Ojeda is on child-related crimes. I determined that 12 o'clock tomorrow, your first intention of assigned public defender to represent.
Shooken, it should be shaken. I think he was going for shooketh, and then he said shooken because he was like shaken, shooken, shooketh. Yeah. I think that she doesn't like facing the consequences of her actions, to be honest, but I don't know. Just from what I heard, it is shaken. She was feeling a bit shaken, not shooken. The other thing I wanted to say is I am suddenly desperate for these very specific frozen roast potatoes, which are in the freezer. So I'm going to make them quick. Apparently, it's been a long time since I've had to stay on my butt and live stream. Also, if I look distracted, it's because I've got a backup of this court going here because they sometimes take down the videos. And then I've got a backup of the one we were watching before going there. And I've got another backup there just in case. So that's why I'm looking down all the time, just to make sure that I get the things.
If you score 5 on the NPRA, we'll start bail hearing with Mr. Reichenberg.
Yes, Your Honor. In this case, the defense scores a 5, as the court mentioned. I do not show any criminal history. However, we are still asking for $1,500 bondable based on the facts as presented in the PC sheet. We're asking for no contact with the 1413 North Virginia Street number E, as well as no contact with Carlos Gomez, Solomon Martinez, who were victims and witnesses in this case. In this case, Your Honor, again, the facts of the case, as far as the violence here, we believe is a concern and a risk to the community. And so we also ask for DAS supervision to enforce those conditions as well. Thank you.
Thank you, Mr. Mayor.
At this time, we would be asking for an OR release with DAS check-ins and a no contact order for Solomon, along with his girlfriend. I do not have her name present with me, but we do think that those are fair and appropriate conditions for her pretrial release. As the state touched on, she has no criminal history. It cannot be said that she is a threat to the community. She also has, again, as a result of having no criminal history, there's no record of her being a flight risk. There's really no need for bail in this matter. As far as the MPRA score goes, 4 points of it was for verifiable information. We were able to verify her employment as a preschool teacher. We were able to verify her residence. She'll be able to stay with her mom for the foreseeable future. And we were also able to verify her personal phone. So she is reachable by the courts. She doesn't need to be held in custody on bail to ensure attendance at future court proceedings. And so we would ask for an OR release with DAS check-ins at this time.
And once again, I'm able to do an OR release. 1,500 requested by the state is not an extreme amount. Telling me that she's not a flight risk. She's not. There's not clear convincing evidence that she's a danger to the community or children in general. I'm going to go ahead with an OR in this case with conditions of no contact. I have Gomez and Martinez. I know I got the names on. Which one is Solomon?
So Solomon Martinez.
Okay, and then the other one was
Carlos Gomez.
Right, all right, go.
And I apologize, Your Honor, the other female mentioned by Mr. Merritt is Jocelyn Padilla, and we would agree with that. No contact with her, Jocelyn Padilla.
Those three and no contact 1413 North Virginia Street, number E, I think it was. No
E,
contact.
yes.
any- Check in with DAS weekly or as often, at least weekly or as often as DAS prescribes. Any other conditions, Mr. Reichenberg?
No, Your Honor, just those. Thank you.
Right, of course, you must make all court appearances. Anything else, Mr. Merritt?
Nothing from us.
All right, thank you. That'll be the order. Next case.
State of Nevada versus Casey Ross.
For defendant Ross, this is a controlled substance case that determined his probable cause for warrant arrest and detention of assigned public defender to represent the defendant. And this is a 6 on the NPRA with an override too high. So I'll start with Mr. Reichenberg. Go ahead.
Yes, Your Honor, on Ms. Ross, we are asking for $2,500 bondable. Your Honor, the defendant does not have an extremely lengthy criminal history. However, concerning for the number of arrests recently for possession of drug type offenses. So I show that her she had a 2023 arrest for a failure to appear in Sparks. I'm unclear what the underlying failure to appear is. I suspect it may be Sparks Municipal Court, although I don't have access to their case system to figure out what is underlying that. Additionally, she had an arrest back in March, wherein she was arrested for possession of drug paraphernalia and resisting a public officer. That was here in this court and ultimately resulted in a plea to the possession of drug paraphernalia back in April. And then she also shows a criminal contempt arrest in March of this year as well. So again, concerning in that she was just in this court not too long ago, as well as in Sparks a year ago for drug type issues, and has not seemed to have been able to get those under control. I would have no objection, depending on where she's at with her understanding of her drug issues, to an IAP transport, if that is something that she is requesting and is willing to pursue. Thank you.
At this time, we would be asking for an OR release with appropriate conditions. I think DAS check-ins plus random drug testing would be fair and appropriate at this time. Looking at the object offense, we're talking about failing to provide proof of insurance and simple drug possession. They're fairly minor charges if you are to accumulate charges at all. You look at her criminal history, she just has the one conviction for possession of drug paraphernalia, and that's it. We're not seeing felonies, gross misdemeanors.
I'm sorry, I have to tell you this before I forget it, because I actually forgot until right now. Jess, who was on the stream a while ago, we went to a charity shop together on Tuesday during our lunch break, and it's like all old grannies that look after the store, and there was like all these vases, and then there was a vase with a pipe just standing there. I don't think they know what it is, and they're selling that vase for like about $1.
Any violent crimes. So she doesn't pose a threat to the community. In addition to whether or not she's a flight risk, I do see the one FTA that populated on the MPRA, but I do think that's undermined by the information we've been able to verify. She does have employment. She does work a regular job, and she does have a place to stay. She'd be staying with her mom if she were to be released. That knocks down about 3 points off the MPRA, and now she's only scoring a 3, which is low. She also has a personal phone number that has been verified. She is contactable by the court. She's able to get updates about when and at what time her court dates are. And I do believe that it is more fair and appropriate to have her on pretrial release conditions as compared to keeping her in custody.
Anybody want to speak to the fact that she was overridden to high?
I don't see the specific reasoning for why it was overridden, because I think when you look at specifically her, right, she has very limited criminal history. The object crime in this matter is drug possession and lacking proof of insurance. It doesn't seem like there's a true justification for the override.
Reichenberg, do you know why?
No, Your Honor, I don't know if it's, again, just because of the kind of recency of these similar, but I don't have any further information.
All right, I don't find there's any evidence that she's a danger to the community, but I do find there's clear convincing evidence she's a flight risk. Struggling between an OR and about a $2,000 bail amount. I don't know, I don't have specifics on why they overrode it to high, but it does show me that she does have some risk here, and I am concerned with an FTA. She, with her record, her employment, her residence, cell phone, everything else, she shouldn't have an FTA, Mr. Mayor. I don't know why she does, but that concerns me somewhat. Not so much of her offenses here. I can understand it. They'll probably be charged all misdemeanors. However, right now I have to give it to favor of the state that the PCS charge is still a felony. I'm going to go with the $2,000 bail. I'm not satisfied in ORing someone that has already shown a risk of failures to appear. So it will be a $2,000 bondable or 10% cash. So it's only $200 cash. I'm sure somebody with a job like she has to come up with that and she'll be able to bail out. But I need her to have some skin in the game, some teeth in this matter. I'm not willing to simply OR her and have her just not show up for court, which is what I am presuming she's going to do, possibly, but probably not with the cash bail posted or a bond. So $2,000 bond or 10% cash on conditions she's checks in with DAS as often as weekly or as required by DAS, and that she have no drugs, no alcohol, no possession or consumption of same, either of both landed back in custody, and that she be tested for in the presence of same by urinalysis or breathalyzer. Mr. Merritt, I don't need to say anything more about it because I'm not ORing her directly, but I would be willing to change it to an OR if she wants to do an IEP transport to inpatient. I don't know that she's willing to with her job and all that, but if that's ever an option, I would be willing to entertain an OR request for that directly. I'm not even going to say it on the record. I mean, I said it on the record, but I'm not going to put it on the JRO that way. I'll leave it up to Merritt if she wants, Mr. Merritt, if he wants to request it. You understand all that, Mr. Merritt?
That's understood, Judge.
Yeah, thank you. All right, anything else from either council?
No, Your Honor, thank you.
All right, that'll be the order then. Thank you. Next case.
State of Nevada versus Caitlin Orr.
And defendant Orr scores a 2 on the NPRA flight risk category. I'm concerned with that, the FTA. And scores a 16. I'm also very concerned with that, but I did determine there's probable cause to warrant the arrest and detention of the defendant and assign the public defender to represent the defendant on these drug-related charges. Mr. Reichenberg will go from there.
Yes, Your Honor, asking for $2,500 bondable bail. The defendant had arrest back in August for trespass that was ultimately dismissed August of this year. At that time, she was also arrested for failure to appear. Back in March of this year, she had a misdemeanor conviction for false statement and obstructing a public officer in Sparks Municipal Court. Back in 2019, then her next arrest before that was a 2019 arrest down in Las Vegas for violating a condition of parole. Actually, she had 3 separate arrests for violating a condition of parole. Had another arrest for loitering down in Las Vegas. That was dismissed in 2019. Had an arrest for burglary in 2018. I don't show a disposition for. Had an intent to utter a fictitious note or bill conviction in 2018 here in the Second Judicial. And then going back, she has history in Nevada back to 2013, also has criminal history in the state of California. Looks like San Jose, Santa Clara County area in 2013, 2014. And so lengthy criminal history concerning for her violations of supervision in the past, as well as her obstructing and resisting with law enforcement. So therefore, we think that $2,500 is appropriate with conditions of DAS supervision and testing for alcohol and controlled substance. I think part of the concern as well is that she, with her case here, was referred to specialty court and failed out of specialty court. Thank you, Your Honor.
Thank you, Mr. Mayor. I'm not likely to OR with a 2 on the FTA and a 16 on the NPRA. So I'll let you start from there. Go ahead.
Understood, Judge. As you assumed, we would be asking for an OR today. That is correct. We do think that DAS check-ins and weekly testing is fair and appropriate under the circumstances. I think while her criminal history is lengthy and her score on the NPRA is high, the underlying offenses are drugs related. That's far better than anything involving theft. Go on.
I'm sorry to interrupt. But I'm looking at fentanyl possession here.
That is the allegation, correct?
Right. I have to take the allegations as true for a bail hearing. Go ahead.
Correct. I'm just saying, of all the offenses to accrue, in comparison to theft offenses or violent offenses, there's a positive in some sense of it just being drugs. She's essentially victimizing herself. Outside of that, something that is going for Ms. Orr is that she does have some support system with her mom. Her mom has been able to verify her residence, has offered to open up her home to Ms. Orr and allow her to stay during this time with her mom. In addition to that, she verified her phone number. So Ms. Orr is contactable for court proceedings. She is able to stay in contact with DAS as well. And I think that significantly reduces the chances of her being a flight risk in function, in practice. So we would be asking for an OR with DAS check-ins and random drug testing.
So you're bringing this up on yourself. If you don't get off the drugs, get off the fentanyl, you're not only a risk to yourself. I don't agree with Mr. Merritt with that. You're a risk to others. Fentanyl endangers everybody. When the police just come into contact with your drug, the fentanyl, it endangers them. Fentanyl is a very dangerous drug just to even touch. It's not quite the same as it was when it used to come out in powdered form. Now it's in pill form. But when it was in powdered form, you couldn't even touch it without possibly getting it into your bloodstream. It's still a very dangerous drug, and you are dangerous in the sense that you are possessing the same. So I find there's clear and convincing evidence with your criminal history, with your NPRA score, that you are a danger to the community and that you are an extreme flight risk, both. Mr. Reichenberg is correct. It's a tough decision and Mr. Merritt's correct. The charges don't cry out for a large monetary bail, but I believe a monetary bail is required as the least restrictive means or alternative to make sure she shows up for court because of these huge criminal history with parole and parole officers, with FTAs, with the court, and the 16 on the NPRA and fentanyl being possessed. I'm going to go along with Mr. Reichenberg on a $2.5 or $2.5 thousand dollar bondable or 10% cash. So it's only $250 cash bail to get you out of jail. It's not an amount disorder whatsoever. It's extremely reasonable. So 2.5 or $2,500 bail or 10% bondable with conditions of checking with DAS at least weekly or as determined by DAS. No drugs, no alcohol possession or consumption will be a violation, and she must be tested for same by urinalysis and or breathalyzer. Any other conditions, Mr. Reichenberg?
No, Your Honor, thank you.
Anything else, Mr. Merritt?
No, Judge.
All right, thank you both.
There's no defendant.
There's no what?
There's no defendant there.
Oh, that's okay.
Okay.
Mr. Merritt, go ahead.
We were just going to ask to waive her appearance as well. Similar condition to Miss Lee. She was just feeling unwell, visibly shaking, that sort of thing.
All right, good enough. And this is for an identity theft related case with when I say a one on the NPRA, that means it's either in the NPRA that way or she showed a prior FTA, even more than 2 years old. So go ahead, Mr. Reichenberg.
Yes, Your Honor. In this case, we're asking for $5,000 bondable bail. The defendant has a prior misdemeanor conviction for possession of drug paraphernalia here in this court from back in March. At that same time, she also was arrested for obtaining an ID of another similar to here, as well as obstructing resisting. She also was convicted of the obstructing resisting. Looks like the ID of another was dropped at that time. She had also back in March of this year an arrest on a criminal contempt. I believe that's probably from conviction for possession of drug paraphernalia out of the Sparks Justice Court from April of 2023, wherein she was also arrested for possession of stolen property. And so again, an individual with not a terribly lengthy criminal history, but concerning for the fact that it appears to be drug and property crime related. When she's contacted with law enforcement, she does not do what she's supposed to do, does not check in with and do what she's supposed to do with courts. And so risk to the community for further issues, as well as risk to not appear. And therefore, we would ask for the $5,000 with DAS supervision and testing for drugs and alcohol. Thank you.
At this time, we would be asking for an OR release of Ms. Russell with appropriate conditions such as DAS check-ins, obey all laws, and random drug testing weekly. Looking at her criminal history, it's fairly minor. It does not include any felonies, gross misdemeanors, or violent crimes. I think that's showing that she is not truly a threat to the community as she stands here today. In addition to that, she did have a prior FTA, but she does not have multiple drug arrests as indicated on the NPRA. I think that bodes well in terms of whether or not she's a true flight risk. Also, I personally represented Ms. Russell in her most recent possession of drug paraphernalia case. While she did FTA at one point, I was able to readily contact her and keep her in compliance to completely close out that case. So while she did have that slip up, she is able to rebound and then maintain contact with the court as required during these proceedings. I think also what's worth noting is that she has a hold out of Sparks Municipal Court. So any amount of bail that would be set here, or if she were to be released on this matter, she's not going anywhere. She's remaining in custody. She has no means to post any amount of monetary bail. So I think the state's request for $5,000 bondable at this time is excessive. I think if the court is inclined to order monetary bail that is reasonable, I think a much more reasonable amount would be $2,000 bondable.
Thank you. I do find that Ms. Russell is a danger to the community, and specifically with ID theft or ID related offenses. To have two arrests for having IDs of another or using IDs of another individual is unquestionably a danger to the community, in my opinion. And I also find there's clear and convincing evidence that she is a flight risk. I call it a true flight risk, Mr. Mayor. Maybe you don't, but I think she's a flight risk. Maybe it's because of use of drugs. I don't know, but she's a flight risk to not show up for court. It shouldn't require you to have to babysit her and call her and get her back into court when you assigned her a date and a time, and she couldn't abide by that. So I do find flight risk and danger to the community. I think a modest to moderate monetary bail is necessary as the least restrictive alternative means of assuring that she shows up for court. Hopefully doesn't reoffend, may not work, but I do consider her individualized characteristics and the nature of this offense, and also the fact that she is indigent, may not be able to afford any bail. I'll go ahead and give a $4,000 bail. I was really leaning toward $5,000. Mr. Mayor, so you said that she can't afford any monetary bail, so I have considered that, but I can't go with an OR. I'll lower it to a $4,000 bondable or $400 cash bail amount with conditions of checking with DAS at least weekly or as determined by DAS with no drugs, no alcohol conditions, testing. I'm going to put a bail loss clause on this one also, just in case she reoffends. I'm going to easily revoke her if there's an allegation she's committed another crime, ID theft related or otherwise, or drug related or otherwise. So I'll throw the old bail loss clause on this one also. And testing with your analysis or breathalyzer. Anything else, Mr. Reichenberg?
Just to clarify, you already said 4,000?
Yeah.
Okay, thank you. Nothing further.
Merritt,
Nothing, Judge.
thank you. Next case.
State of Nevada versus Marwan Abdul Jalal. Say his last name.
Yeah, does it say with a no?
A.
Oh, way back up there, that's right. All right, defendant, I can't pronounce last name either. I can't even pronounce the first name, so I've determined there's probable cause to warrant the arrest and detention of the defendant. Scores a 1 on the NPRA for domestic battery related offenses and prohibiting or preventing the use of calling 911. And I've assigned the public defender to represent the defendant. Mr. Bail hearing with Mr. Reichenberg.
Your Honor, may I ask, the victims, I believe we're going to try to,
They're logged on.
okay. Oh, perfect. So Your Honor, in this case, we are asking for $10,000 bondable bail. Our investigator's office were able to speak with the victims earlier this morning. And I would, again, let them know that the court will turn to them if they would like to speak this morning. I believe they just want to observe today. However, they let us know that they would like a no contact order. The daughter applied for an emergency TPO yesterday, but she said she had not heard anything about it. I'm not sure if the court shows that TPO or if the jail knows if he has been served with the TPO at this time. However, they are asking for a no contact order, and so we are asking for the no contact order pursuant to NRS 178. And I can't remember if I said the $10,000 bondable bail already, but we're asking for $10,000 bondable bail. The victims have indicated that the violence in the home has been going on for an extremely long time. The wife indicates that she's been trying to avoid him and she can't take anymore and would like to proceed with divorce proceedings. I would note that there was also a report that just prior to a few days prior to this, that the defendant choked a younger brother in the household. I would also note that the defendant had a 2019 arrest for preventing or dissuading that was ultimately pled down to a misdemeanor conviction for coercion.
TPO is a protection order.
And then I also show a 2016 domestic battery arrest that I do not show a disposition for. And so again, I think that adds some credence to what the victim said. Essentially, the abuse has been going on for 24 years at this point. I think this is concerning in the way that I think oftentimes in the state's view that some of the most concerning cases of domestic violence are the ones that occur for a long time outside of the view of law enforcement because the victims are too scared to report. And it appears that this may be one of those cases where in lengthy criminal history, we show some arrests with minimal dispositions, but I think that adds credence to what the victims are reporting. This has been a long ongoing scenario. And so we are also asking for no contact with the 205 Orcrest Drive address, as well as Miss Omer, who was Hidayat, and I apologize, I'm going to mispronounce everyone's names as well. Miss Omer's name, as well as Amal, AMMAL is a first name, and same last name as a defendant, Abdul Jalil, I believe, Abdul Jalil. And with that, Your Honor, I would submit.
Thank you. Either of the victims want to
Felt like a weird time to say thank you just then. Thank you so much, Laura. I really appreciate it. Don't tell Vaughn. I might take it all for myself. You know, it's okay. We won't prenup. No, I'm joking. I'll share. That is very generous. Thank you.
be heard? I take it no, Mr. Breckenridge?
Yes, right. I believe so. That was my message, and then I believe they confirmed that to Madam Clerk through the link that they did not want to be heard.
Thank you. I just need a yes or no. Mr. Merritt?
At this time, we would be asking for an OR release with appropriate release conditions. BAS check-ins would be ideal. The stay away and the no contact orders are also amenable at this time. When we take Mr. Abdul Jalil in his entirety and specific to him, there's a reason why he scored a 1 on the MPRA. It cannot be said that he is a true threat to the community nor a flight risk. I don't think bail is necessitated under these circumstances for Mr. Abdul Jalil to ensure safety of the community. On top of that, to ensure future attendance at court appearances. If we are to take what the state has implied, that he has perpetuated some type of violence against family members over the past couple of years, that it sounds like the violence would only be confined to these individuals. I think the no contact orders and the stay away orders sufficiently protect the alleged victims in this matter if we are to take the allegations as fact facially. In addition to that, we can also implement a GPS monitor and house arrest requirement if the court finds that it is appropriate and necessary. It's just that at this time, it doesn't seem by clear and convincing evidence that he is actually a threat to the community, just given his absence of criminal history, save it be that one misdemeanor conviction. There's also just no record that he is a flight risk whatsoever. We were able to confirm that he does have a job currently at the Silver Legacy, so he is employed. He does have something on the line if he were to miss future court proceedings or to remain in custody. And so at this time, we would be asking for that OR release.
Thank you. These type of crimes present a strange dilemma for the court where you kind of get both extremes, because at one extreme, we have serious nature of the offense, severity and threat of danger to the individual victims, not so much the community in general, but it's clearly a serious threat to the individual victims in this case. And then on the other hand, we have the extreme of someone scoring a 1 on the MPRA tool, which is designed to determine whether somebody is a risk to others, danger to the community, and or flight risk. I do not find that the defendant is a flight risk, but I do find there's clear convincing evidence, not that he's a danger to the community in general, but a danger to these specific victims, which the case law clearly describes as also a danger to the community. And this one is very serious because it's so long-term, 24 years. So I can't OR, and I don't know if any amount of conditions, Mr. Merritt, GPS and others would be enough to guarantee that he's not going to be a risk of retaliation or risk of reoffending against these victims. Also, no monetary bail can safely, assuredly prevent somebody or guarantee somebody's not going to reoffend. So that's the dilemma I struggle with. And someone that scores a 1 on an MPRA normally is entitled to an OR. But when you deal with domestic battery and preventing somebody from calling for help, 911 call and whatnot, that's the serious concern I have. So I do find that he is a danger to these individual victims. There's clear convincing evidence of same. And although he scores a 1 on the MPRA, I think a moderate amount of bail is necessary. It's not enough to keep him from bailing out or getting back into the community. I understand that. It's not enough to adequately assure me he's not going to reoffend. But no amount of bail would be. I can make it $1 million. If he could post it, the same risk would be outstanding. So I'm going to go along with the state's request here and make it a $10,000 bail. It is going to be bondable or 10% cash. So it only takes $1,000 cash or $10,000 bondman or bond to bail out here. And like I said, I don't care how high I make it, he might be able to afford it and bail out. So that is not deemed as punishment. It is not deemed as something that's absolutely going to guarantee he won't have a chance to reoffend. But that is what amount I feel is the least restrictive means or alternative I would be willing to consider, hopefully assuring that he won't reoffend and will make all court appearances. It will come with conditions of no contact and no going to the residence. Mr. Reichenberg, I thought you said 205, but I have that it's 305 or Crest Drive. Is that correct?
Correct.
Sorry, I must have had a typo when I typed it into my notes this morning. Yes, it is 305. I apologize for
I
that.
might have just heard it wrong. It doesn't matter. I just want to make sure we get the right address. All right, 305 Warcrest Drive. No contact with those individual victims that Mr. Reichenberg has identified by name and that are also in the probable cause sheet in this case. I'm going to make him also have a GPS monitor. It doesn't come with house arrest, but it does come with GPS monitor, Mr. Merritt, and that will be installed upon him prior to his release from jail so that VAS will know his whereabouts. He's to check in with DAS at least weekly, if not more often, as determined by DAS. Any other conditions, Mr. Reichenberg?
Your Honor, if we could make the no contact order pursuant to NRS 178 such that it's a new offense. And I would note that the victim indicates that in the past, his family has commented to her and shamed her for calling police in the past. So to ensure that he knows that he can't be contacted through a third party as well. Thank you.
All right, sir, the defendant, you are ordered pursuant to statute, NRS 178.4845, that you be notified that any contact, direct or indirect, so you can't have somebody else contact the victims. You can't do it by email, text, phone call, or in person, or any other method or means to contact or have somebody else give them a message. Do you understand that?
Sure.
And that comes with the notice to you today that it not only would be a violation of my conditions here and warrant you being placed back in custody, being arrested, it also would constitute a separate criminal offense pursuant to that statute. So I need to notify you of that. So no contact whatsoever. Anything else, Mr. Reichenberg?
No, Your Honor, thank you.
Anything else, Mr. Merritt?
No, Judge.
That will be the court order. Thank you.
Did you order firearm?
I did not.
Okay.
Thank you, everyone.
Next case, state of Nevada versus James Lawrence.
Mr. Lawrence, this is a possession of motor vehicle case, possession of stolen motor vehicle case and other offenses. You scored an 8 on the MPRA. I determined this probable cause to warrant your, I didn't, but Judge Darling did, to warrant your arrest and detention, and he also assigned a public defender to represent you. Sorry about the numerous days of delay that we've had in this case. It appears that pretrial services was trying to verify or confirm your identity, but we're here today ready for bail hearing, Mr. Merritt, correct?
Sorry, Judge, it kind of broke out for a
Okay, while this plays, I'm gonna go and find him in court yesterday because the lawyer was funny.
second. What was that?
We're here for a bail hearing on Mr. Lawrence today, correct?
That is correct.
All right, we'll start with Mr. Reichenberg.
Yes, Your Honor, in this case, we are asking for $20,000 bondable bail. The defendant has a lengthy criminal history, primarily out of state. He has criminal history that's extremely concerning for violence and again, multiple states. So state of Washington, he had an assault with a deadly weapon and firearm case in 2018 that it appears he was convicted of. It's a little bit unclear to me, although it says that he went to the Department of Corrections in Washington on that case, I believe, for the burglary portion of that case. he was looks like certified as from a juvenile up to an adult in the state of Washington. Had a prior motor vehicle theft case where he was convicted, I believe, of the theft of the motor vehicle back in 2014. Had a robbery with the use of a deadly weapon in Washington back in 2013, felony conviction. Had another robbery charge that looks like it was dismissed. Had another theft of a motor vehicle arrest in 2012 that I don't show a disposition for. Has history going all the way back to 2007 in the state of Washington. Assault, theft, burglary, sorry, going back to 2002, I misread my notes, going back to 2002, kind of consistent amount of assaults, robberies, things with firearms, stolen property, and has also federal charges. I show a 2003 federal charge for, I believe in Spokane, Washington, for a prohibited person in possession of a firearm, as well as a 2004 escape from custody on that charge. And so lengthy criminal history, lots of violence. Large amount of that history is in the state of Washington. Unclear to the state if he has really any connection to the Northern Nevada area. And so we believe that he's a risk to the community, risk not to appear given his lack of contacts, and believe that bail will be appropriate with EAS supervision, no weapons, as well as house arrest monitoring. Thank you.
Thank you, Mr. Barrett.
At this time, we'd be asking for an OR with appropriate conditions. I'm looking at his NPRA right now. I think there's a couple of things going for him, just in general. I'm seeing that he has no prior FTAs within the past 24 months. I think that indicates that at the very least, if he's ordered to go to court, he will go to court. He also has a verified cell phone. We were able to get that through our own contacts with our investigator. He is reachable by the court. I believe through our conversation, he indicates he intends to sleep at the CARES campus. That has a great relationship with the court. In fact, offers a shuttle service between CARES campus for court dates. I think with some type of setup such as that, I believe Mr. Lawrence could be an adequate candidate for an OR release and able to make future court proceedings. I also see on the NPRA, he scored no points under the substance use multiple arrest category. That further shows that to some extent, he is not showing the key signs that you ordinarily would see with somebody who's not supervisable and who's unlikely to show up for court at later proceedings. I do think if the court is inclined to set some type of monetary bail, I do believe a much more reasonable amount would be in the amount of $5,000 bondable with a 10% cash option.
Thank you, Mr. Merritt. I'll consider the 5,000 whether that's enough or not. Certainly, I can't go lower than that. I don't find that he's a failure to appear or flight risk, so I don't find clear and convincing evidence of that. But I do clearly find clear and convincing evidence that he is a danger to the community, and it sounds like many communities throughout the country. The charges themselves: possession of motor vehicle, obstructing and resisting with a deadly weapon, felony eluding, and hit and run. Tell me all I need to know about how dangerous it is. So I do determine there at least a moderate, if not more, bail amount as the least restrictive means or alternative. I do not believe that the conditions alone would be enough. I do not believe that $5,000 bail would be enough to keep him from reoffending. So it may mean that he doesn't get out. I don't know, that's up to him, but the $20,000 bondable also comes with 10% cash out, but only $2,000 bail, which anybody could look at and see that that is extremely reasonable. But not many people have that kind of cash, especially somebody that's going to be staying at CARES campus. So I understand that also. Taking all the factors in 178, chapter 178 into account, his individual characteristics, I agree with the state. I'm going to go with
What
$20,000
wipes?
bonding or 10% cash.
They were on the
out.
kitchen
Come
counter.
with conditions. I agree with you, Mr. Mayor, on the house arrest. Mr. Reichenberg, I guess it was Mr. Reichenberg. On the house arrest, I think that is necessary in this case. I don't necessarily need a GPS monitor, but the house arrest will be.
They were in the middle on the
I
counter.
don't know how that applies to CARES campus.
I know
I've
there's
never had
some
that
in my
on the account.
bathroom, but they
Maybe
were,
council, does
there
CARES
was
campus
extra when
consider
it
home,
opened.
I guess, and he can leave for coming to court, or whatever, going to work if he works. Is that how Pierce Campus is operating under a?
Oh,
under
I
a-
finished some,
Your Honor, I'm not sure. I do believe in the past when I've seen individuals at
but
CARES
there
campus,
was another
we have
one
to fix them
open.
with the GPS. And then that way they can be monitored at CARES campus. I do not know that there was any ability to essentially make them stay at CARES campus.
Yeah, I'm gonna take it off altogether. Mr. Riker. I like the GPS on this. So I'm gonna take off the house arrest with GPS. If he wants to stay at CARES campus, he can do so as little or as much as he wants. That's how CARES campus usually operates. So basically what we're looking at is condition of checking with DAS at least for videos to by them. Any other conditions requested, Mr. Riker?
No weapons, Your Honor. Again, it was a knife or a machete in this case, and should be prohibited from firearms given his numerous felony convictions.
No firearms or other weapons. Any other conditions?
No, Your Honor, thank you.
Is there anything else?
No, Judge.
All right, that'll be the order. Thank you, everyone. Next case.
State of Nevada versus Richard Medina.
Okay, we're gonna go to yesterday. Give me a minute. Here's yesterday. Nice. Is there, now I've broken it. Is this working? Can you hear this? Is everyone having, okay. Can you hear me though?
Of weapons. We'd also ask for no
StreamYard increased their prices and decreased their reliability.
For testing for drugs and alcohol, given the numerous previous convictions for that. Unclear from the PC sheet because there was kind of a period of time between when the victim could report this and also when the defendant was arrested, whether or not drugs or alcohol, what role that played here. But again, given the lengthy criminal history there, we believe that's an appropriate condition as well. Thank you.
When you say a registration violation, are you referring to registration as a felon?
Sex offender, Your Honor.
Oh, felony? Oh, boy, okay. Go ahead, Mr. Merritt.
At this time, we would also be asking for an OR release with appropriate release conditions. I think the bulk of what the state was asking for is fair and appropriate under the circumstances. A no contact order, no weapons clause, and DAS check-ins. I don't necessarily think there's a sufficient nexus to warrant drug testing or alcohol testing, just given the fact that the allegations here don't talk about at all any drug use, any alcohol use. No witnesses that were spoken with mentioned any type of intoxication coming from my client. In addition to that, the MPRA indicates no multiple arrests for substance use in the past 10 years. I believe my client used to have a drug and or alcohol issue in the past, but he has been on the straight and narrow for the past 10 years, as it indicates in the MPRA. I do not think drug testing or alcohol testing is appropriate, but to the same extent, if the court feels that it is appropriate, my client is willing to abide by that.
I don't, enough of that.
All right.
Go ahead.
Outside of that, the state hinted at it. The worst of my client's criminal history is stale. It is of the past. It is older. His more recent actions, as reflected in the MPRA, no prior felony or gross misdemeanor convictions within the past 10 years. He does have some violent crimes. However, they are minor misdemeanor crimes. In addition to that, on the MPRA, it indicates no prior FTAs within the past 24 months. His recent history shows that if he is ordered to show up to court or to do XYZ thing as ordered by the court, he will do it. Then we go to the lower part of the MPRA. His employment status has been verified. He also has a verified landline or cell phone. That means he is reachable by the court. And so he can be kept up to date and informed as to whether or not he has an upcoming court date, what that time is, so that he knows when to show up. We've also been able to verify his housing situation and currently some form of his income. He is in between housing at the moment. He currently resides at 1244 Carville Drive. However, he is in the process of being evicted, so he would be moving to a shelter in the local area. Again, CARES has a great relationship with the court. I think if he did end up at CARES, he would be in a good spot to make every upcoming court appearance. So that is the basis for our request for an OR at this time.
I'm just moving completely.
Remind me what the
I don't need to be there.
the dental surgery that was required in this case. He had a fracture of the jaw, is that correct?
Yes, he has fractures to the face and jaw, and says nerve. What I have in the PC sheet is nerve damage that will, and the recovery process is approximately 1 year.
That concerns me, even though his record may be somewhat older, Mr. Merritt, he's an ex-felon, he's got a considerable record of batteries and violent offenses. Now here we are again with battery causing substantial bodily harm that is extremely concerning to the court. I do find that he's a danger to the community and to this individual victim specifically, and there's clear convincing evidence of same. I consider the lowering of the bail of the MPRA from 7 down lower, as Mr. Merritt has suggested. I've also considered the facts of this particular case, which are quite concerning to the court. I'm going to do this. I'm going to establish a moderate monetary bail amount as being necessary as the least restrictive means or alternative to warrant his non-commission of further offenses such as this, and also to appear in court. It's going to be a $7,000 bondable or 10% cash.
Your Honor, I believe the 10%.
Category A or B, right? I got you.
Yes,
If
it'll
that's
be
the case, I'll lower the bail more. Which would you prefer, Mr. Reichenberg?
Your Honor, we would ask that it not be the 10% cash, yes, it's a B with a victim.
All right, there'll be $5,000 bail bondable or $5,000 cash. It will not come with a 10% cash option under our policies and procedures by our chief judge's administrative order. Cat A or Cat B felony with the victim is without the 10% cash option that we give many other offenders. So it'll be $5,000 bail or $5,000 cash with conditions of no contact whatsoever with the named victim. And Mr. Medina, that comes with under chapter NRS 178, and more specifically 178.48545, indicating that this will be a separate criminal offense if you do contact the victim even in any way, even to apologize, even to say you're sorry, which you shouldn't do anyway during a criminal proceeding, because it would be an admission. But you shouldn't contact the victim whatsoever, or it will be a violation of the condition of its bail, and also a separate criminal violation. All right, you're also to check in with DAS at least weekly or as warranted by them. I'd like that to occur before he leaves the jail, so he goes through orientation with DAS prior to release. That may not be able to occur till Monday, even if he's able to post the bail. Mr. Merritt, they may keep him there till Monday because that's probably the first time he's going to have a chance to meet with DAS. He's to have no possession of any firearms or other weapons. Any other conditions requested, Mr. Reichenberg?
Yes, sir. We asked for no contact with the Go Mart where this occurred at 1755 Sutro Street.
Granted, that will be also ordered. He cannot go on the premises or on their property or in that store whatsoever. Anything else?
All right, thank you.
Thank you, Mr. Merritt. Anything else?
No, Judge.
That will be the order. Thank you. The next case.
State of Nevada versus Samuel Morin.
Mr. Moore, I've determined this probable cause for warrant of arrest and detention of assigned public defender to represent you. You score 9 on the NPRA. In this grand larceny and related offenses. I have a note to myself here. I don't think it was from the NPRA council that this is also aggravated. In other words, to be increased from the 9. I don't remember my exact reasoning. He does show a 1 on the NPRA failure to appear category. But I wrote that perhaps this should be overridden from the 9. I don't remember why. All right, Mr. Reichenberg, go ahead.
Yes, Your Honor. In this case, we are asking for $15,000 bondable bail and no contact with the 4780 Warren Way, as well as no contact with the victim, Frederick Morin, the defendant's father. Your Honor, the defendant has a concerning criminal history, not extremely lengthy, however, has criminal history going back to 2007, wherein he pled guilty to a gross misdemeanor conviction for conspiracy to commit grand larceny. He also had a failure to appear on a traffic case from Reno Municipal Court in 2018, and then a trespass arrest in 2020 that I don't show a disposition for, and then a conviction in the Sparks Justice Court for possession of drug paraphernalia earlier this year, and a failure to appear arrest again out of Reno Municipal Court when he was here. So again, concerning some drug offenses there, and again with the grand larceny and larceny type priors, it appears that substance abuse may be a driving factor for his property crimes, and so we would ask that he also have DAS supervision with testing for alcohol and controlled substances as well. Thank you.
At this time, we would be asking for an OR release with appropriate conditions. I do think DAS check-ins would be important to maintain so that Mr. Morin can maintain contact with the court and maintain his compliance. Also, a no contact order with the alleged victim makes additional sense, as that is the only person truly affected in this matter. Looking at his scoring on the MPRA, he scored 0 in the felony and gross misdemeanor category within the past 10 years. So he is not committing major crimes within the area if he's committing any crimes at all. In addition to that, he's not scoring any points in the violent crime category. So whatever crime he is committing, it is not in causing pain, strife, physical issues to another person. It seems to be boiled down to, if we take the allegations at face value, just theft. I believe the judge, Your Honor, I believe you mentioned that he scored a 1 in the FTA category. What I'm seeing is that he has 0 points.
No, I said this earlier, Mr. Merritt. You weren't listening to me when I said this before. When I call it an FTA category, I'm talking about my own brain, more or less. I see he shows a 0 on the NPRA, but the FTA has that Reno Municipal Court counts to me. So sometimes even if it's more than 2 years old, I'll still put it down, in my opinion, as an FTA, a 1. That's what I was referring to. I see that the NPRA has it at 0 because they were only looking at the last 2 years. My brain goes a little farther back than that. So that's what I was referring to, but you are correct. Go ahead.
Well, Your Honor, I would note that, as I mentioned earlier, at the time of this arrest, he had a arrest for failure to appear from Reno Municipal Court. So he currently has a failure to appear out of Reno Municipal Court. I'm not sure why they missed
I know,
that.
I don't know why MPRA didn't put it in there. Either way, I heard Mr. Reichenberg loud and clear. I was aware of it. So in my head, I put it down as a 1 in the FTA category. But either way, go ahead, Mr. Mayor.
Yeah, no, I appreciate the clarification. And then we're looking further. He scored 4 points for verifiable information. We were able to contact one of his references who verified his employment, also verified that he has a place to stay once he is outside of custody. That would knock it down by, I believe, 3 points. And so he's truly scoring a 6 at that time. In addition, you see the substance abuse arrests for the prior 10 years. He scored no points in that category. I also wanted to correct something the state mentioned in their recitation of his criminal history. The criminal history that we received in accordance to this case indicates a PCS and a PDP arrest dated this February 5th, 2024. In this same record, it shows that both of those charges were dismissed outright, so that there shouldn't be any conviction for either of those charges. I just wanted to clarify the record and preserve it at this time. I think just considering Mr. Moore in his entirety, and also what he is most likely to do given his recent behavior outside of these allegations, I think he doesn't need to be retained in custody to ensure protection of the community, plus ensuring that he shows up to later court proceedings. I think you can achieve that with the DAS check-ins and the no contact with his father. I think that protects the community because it keeps him away from the person that he allegedly harmed in this matter. In addition to that, it maintains contact between himself and the supervising agency so that his chances of maintaining appearances going forward are also heightened. Right.
Thank you, Mr. Mayor. I remember why I put it as aggravated in my mind, something that wasn't mentioned in the MPRA. It's because of the amount. This was listed as a grand larceny of over $100,000. That's why I put an aggravation asterisk on my notes. Mr. Reichenberg, do you want to talk about the amount stolen here?
Yes, sir. So it was indicated there was $100,000 worth of silver and then $3,000 in cash taken from the safe. I would, Mr. Merritt referenced my the 2024 case. That's correct. I appear to have misread my notes on it. He was ultimately convicted of the drive while suspended license, and the counts 1 and 2 were dismissed. I misread that. However, I would note that in March after that arrest, he tested positive for methamphetamines and was referred to outpatient treatment while that case was pending. So he was not convicted of the possession of drug paraphernalia. However, I stand by the comments that drugs appear to be problematic in his life. Thank you.
All right, I'm wondering, Mr. Reichenberg, I'm not sure I can find it to be a clear and convincing evidence or clear and present danger to the community, even to his father specifically. He might be a thief, but I don't see him as a danger. And then the failures to appear are close. I don't know if I can find enough from the record to say that there's clear and convincing evidence he's a flight risk. So if I can't, just putting out on the record what I've just said, I'd have to OR him. Would you agree with that, Mr. Reichenberg?
Well, all right. I think one of the things that's concerning to the state as far as his risk to the community is that, again, with the recent drug case and the talk of going to inpatient, and then the fact that he went into his father's house and stole an extremely large sum of cash, and as noted in the PC sheet, he had previously as noted in the PC sheet, he had stolen it from the kind of hidden safe area. I think that shows that he, in the lifespan of cases in the state's view where people have drug problems, it's oftentimes they first start to steal from their own family members, and then as the drug addiction takes further and further hold, then they start stealing from others. I understand that that's kind of a generic pattern, but I do think that he was willing to steal 6 figures worth of value from his own father. I think that presents a concern for whether he would, engage in that further activity unless and until he addresses the substance abuse issues.
Yeah, I have to disagree with that, because as I stated, the drug use and the thievery do not make him, in my opinion, a one-time circumstance to be a danger to the community. In other words, the less restrictive means or alternatives of putting him on testing with DAS would take care of that. If he can't get rid of his drug problem and he stays on drugs, he'll be rearrested by DAS. So I can't establish, in my opinion, under Valdez Jimenez, a good enough record or in my own brain, something that leads me to conclude that I must give him a monetary bail. I agree that the MPRA is 9, at least the starting MPRA amount is 9. Was the victim notified in this case of the bail hearing today, Mr. Reichenberg?
Your Honor, because it was a grand larceny, he was not noted. We did not have a chance to contact him this morning.
What do you mean because it was a grand larceny? In other words, you yourself are not taking the crime seriously?
No, so in our office, with our investigators, it's crimes of violence that we prioritize as far as reaching out.
Right, that's exactly what I'm saying. You're saying the same thing I am, exactly why I don't think I can deem him to be a clear and present danger or clear convincing evidence to be a danger to the community, exactly what you just said. So I have OR, I don't see a second way or another way around it. I'll make the conditions as specific as I can to hopefully keep him from reoffending. But I don't have really good evidence of the FTA, the MPRA itself, but FTA says a 0. So I'm not making a good enough record of that just because I was concerned about the Reno Municipal Court case FTA. I don't think that's enough to give me a reason to believe he won't show up for court. So I'm going to have to OR against my better judgment. I will say that in this case, Mr. Moore. I'm going to OR you today on some serious conditions. Number one is that you not have any contact with your father. You not have any contact with the business. What was the name of the business, Mr. Reichenberg?
The address is 4780 Warren Way.
Is that the house or business?
I believe that's the address where the items
I know
were
it's where
taken
the
from.
safe is. So is that a house or a business?
I believe that's a house, Your Honor.
All right, no contact with your father or your father's residence. Don't go near or on the property of either. You must check in with DAS at least weekly or as determined by DAS. You're to have no firearms or other weapons. I want you on GPS monitoring and house arrest. So wherever you're going to be living, you'll be on house arrest and a GPS monitor installed upon your ankle before you are released from the jail. Any other conditions? The testing. Yes, I'm going to go ahead and order no alcohol, no drugs. You'll be tested for the same by DAS randomly without notice, and any positive test will also result in your arrest. Or if you don't report to DAS, you'll be arrested. Any other conditions, Mr. Reichert?
No, Your Honor, that's it. Thank you.
Are we gonna do the GPS like we did yesterday,
Yeah, not till Monday, yeah.
Monday? Because of
Yeah,
the holiday?
they're not gonna be able to hook up the GPS till Monday, Monday, because DAS is not working. So Mr. Moran and Mr. Merritt, I can't order that be done before he'd be released from jail, or he'll end up spending an extra 2 or 3 days in jail. This
Understood.
is an OR. This is an OR, so I'm going to require that he get the GPS installed by DAS on Monday by 5 o'clock. If he
Yes, sir.
doesn't, GPS on Tuesday will issue or ask me to issue a warrant for his arrest. You understand that, Mr. Moran?
I understand.
You'll also be on residential confinement. DS will go over that with you also. Anything else, Mr. Merritt?
No, Judge.
All right, that will be the order, everyone. Mr. Reichenberg, anything else?
No, Your Honor, thank you.
All right, Mr. Moore, don't make me eat this ruling. I want you to make sure you show up for all court appearances and no
I will.
more offenses. Don't obey the law. Don't get arrested for anything where this case is proceeding. You'll be back in jail on this case. You understand?
Yes, Your Honor.
So we'll go ahead and put no bail on this case also. All right, that'll be it then. Thank you. Is that the last case? Mr.
That's it?
All right, Mr. Deputy, that's, I think, our last case. Mr. Reichenberg, is that your last one? that you
Yes,
show?
Your Honor. Thank you.
All right, and Mr. Merritt, same question?
Okay, let me just find the button that is the button. Can you hear me okay? I chose the exact same time as the kettle boiling to speak. I don't know why. Well, actually I do because it was the end of the video. So what I wanted to say is I'm just easing back in. So we can watch for a little while longer, but I don't want to get a late night because it has been wild. Obviously, we had an entire wedding and everything that followed that. And from now until Jan, I don't know how much I'll be live. I'm going to do my best. But what I definitely plan on doing is all of the stuff that I watched but was either like traveling or stuff that I watched and I saved, I will be putting those out as much as I can. So there might be days where I have like 5 videos posted in one day. I just want to clear out the archives. I've got so much of that. And I'll make them premieres so that chat's available, but I can't actually come back fully until I've had a break, or we're going to have a very burnt out Vicky. So I'm going to take us to the world's noisiest courtroom. If it's too noisy, please let me know, because I often watch this one with headphones, subtitles on, but they have really strange things because it's Detroit, however you say it. Magistrate Burton, and then one of the lawyers are my favorite, but they've just cleared out the whole playlist. So we've got this lady today. Can't remember her name. Detroit.
Ms. Carla, good morning. Good morning to this honorable court. I'm here on
Thank you,
I'm here on Mr. Hicks.
Hicks. I saw Hicks somewhere. Rael?
Yes.
Okay. Ms. Carla, what's your P number?
62755.
Thank you, ma'am.
Thank you.
Good afternoon, DDC.
I'm gonna talk to the judge a minute, hold on.
Central City. Good
Pardon me?
afternoon, Council Ragnan.
Central City. It is the city of Detroit.
Okay. Council Ragnan, I'm gonna mute you. There's a David Draper. How can I help you, sir?
I am retained counsel for Timothy Kelly. Do you show him on the docket today?
Kelly. Last name is Kelly?
Correct, Kelly.
No, sir. No Kelly on the list.
Well, then I will bid you adieu and thank you and happy holidays.
Happy holidays, sir.
Thank you.
Your Honor, may I mention something to you, please? First of all,
Yes,
good
sir.
morning. I have a tech support person on the phone because I've had no emails all morning. We've had to use a different computer to try to get the log sheet, which I got about 10 after 11 this morning. And he's on the phone trying to fix it. Perhaps we could wait a minute.
How much time?
Oh, you got,
We
hold on.
got retained counsel on one. How much time do you need, Council Ragnan?
No, just 1 minute. Okay, what's the ticket number? 3. Okay, I will call the tech support on Monday. Thank you. It's very nice of you to help me out. Appreciate it.
So Council Ragnan,
Yes,
does that mean you're ready to proceed?
I am ready to proceed. I've only got 7 cases done, so we'll get on them.
We'll go each by case. The gentleman in white, what's your name, sir?
Brian Adams. Brian Adams. Brian Adams. Yes, ma'am.
Adams, Brian. Okay. DDC after Mr. Adams. Okay. DDC after Mr. Adams. Can you bring Rael Hicks, who has retained
I
counsel?
just called the after-hour number.
All right. All right, Mr. Adams, this is Magistrate Chuck
Yeah,
Bass.
right in the middle of the hearing.
Hold on. We still need defense counsel. Stand by.
Thank you so much. I did call somebody else's private number, left a message there as well. But I'm sorry. They have emergency service. Yeah. Okay, well, thank you so much, and you have a great day, and I sincerely appreciate you calling me back.
Adam, stand by. We're waiting for your attorney to sign on.
Thank you.
I know. Well, because that way I don't have to go, but I guess I have to. He's not picking up. But he would have been in the room. Mr. Adams, your attorney should be signing in about now. Yep. All right. Mr. Adams, please say your full name again.
Brian Adams. Brian Adams.
Okay, again, he signed in. Now we go. Mr. Adams, again, your name, your attorney's here again.
Brian Adams.
Mr. Adams, I'm Magistrate Chuck Bass. Thank you for your patience. Your case number is 18058170001. You have an attorney. Go ahead, counsel.
Ryan Murad, PA 3665, on behalf of Mr. Adams, we waive formal reading. Mr. Adams stands mute. He's been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court dates are January 8th, 2024, probable cause conference, followed by preliminary examination, January 15th, 2024. Both matters on front of Judge Giles. Mr. Adams. Okay. Council Ragnan, this is child support, failing to pay. Do you represent the people or not?
Well, yes, it's just a
Okay.
continuation.
Go ahead. Give
Well,
me a
Your Honor, in this
recommendation.
case, Samuel A. Ragnan, P23-157, on behalf of the people. Good morning, Your Honor. Good morning, Mr. Murad.
Morning.
The defendant was ordered to pay back on 9/27/2004, $21.75 a month. And his arrearage now is $39,130. So we're going to ask for a $10,000 personal bond in this matter, Your Honor. So hopefully he can work, start paying back.
No objection, Your Honor. He's unemployed. He fits the good cause requirement. of the
That's
statute.
fine. Bond in this case is $10,000, personal bond, 2018, charges non-assaultive. Thank you, Mr. Adams. Nobody has to pay any money for you to get out of jail. Just go to court. You can
Thank
step
you.
aside, sir. Bless you, ma'am. Gentleman in white at DDC, what's your name, sir?
Real Levi Hicks.
Is it Brielle Levy Hicks?
That's Levi, yes.
Thank you, sir. This magistrate check there. Your case number is 24060787001, sir. You have the counsel. Go ahead, counsel, Marable.
Good afternoon to this honorable court. Carla Marable on behalf of Mr. Hicks. We waive the formal reading and stay on mute, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are December 6, 2024, probable cause conference. Followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Jefferson. Mr. Hicks, while this case is pending, you're not to possess any firearms of any kind, any ammunition of any kind. Do you understand those bond conditions?
Yes, ma'am.
Okay. Counsel Ragland, the charges are non-assaultive. That has the bond recommendation.
People have asked for a $10,000 personal bond, Your Honor. Thank you.
Your
Thank
Honor,
you.
the defense agreed with a personal bond.
Thank you.
Okay, thank you. Bond in this case is $10,000 personal bond. Mr. Hicks, nobody has to pay any money for you to get out of jail. Good luck. You can step aside, sir.
Thank
Good
you.
afternoon.
Everybody have a good afternoon. Bye-bye.
Thank you.
Bye. DDC, if you want, we can start from page 1, going down the list.
I'm going now.
What's your name, sir?
I'm Edwards.
Mr. Edwards. Sir, this is Magistrate Chuck Bass, sir. You're here on a criminal matter. Case number is 240-4474801. You have an attorney. Go ahead, counsel.
Ryan Murad, PA 3665. On behalf of Mr. Edwards, we waive the reading. Mr. Edwards stands mute. He's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court date is December 11th. Let me repeat that, December 11th, 2024. A review court date in front of Judge Austin Garrett. Mr. Edwards, while this case is pending, you are not to possess any firearms or any other dangerous weapons, and you're not to have any contact with the James Easley. Do you understand those bond conditions, sir?
Yes.
Okay. I also have, as of August 12th, 2024, a warrant was issued for Mr. Edwards, failed to appear. Bond, the KPS amount is $1,000 cash with GPS tether. Defendant cannot appear via Zoom.
Yes.
Council Reagan, go ahead.
Is he charged with felony?
No, it's misdemeanor.
Well, we would appear on this matter, Your Honor, and we feel like just a personal bond would be appropriate. Bond of $10,000 personal bond. Give him a chance.
No objection. Thank you, Mr. Ragnon. We'd ask that that be imposed.
Okay. However, while this court does have the authority, Judge Garrett has indicated he can't not appear via Zoom. $1,000 cash, GPS tether. This is August 12th. KPS. He's got, let's see, another KPS, May 28th, 2024. I'll make sure if that's.
She's on
it.
probation for
He's got- Okay, well, it's for sentencing. So KPS, this court is not going to change that. We're going to leave it at $1,000 cash, GPS tether. He cannot appear via Zoom. December 11th. Okay. Council Murad, is this unaffordable?
Yes, Your Honor.
Okay. That means, let me make sure. That means his next court date will be December 3rd, which will be this Tuesday, December 3rd, 2024, 9 o'clock in front of Judge McConnell or Judge Williams, who will look at the bond amount and bond conditions.
Okay.
Thank you, Your Honor.
I'm sorry.
I'm sorry. It is literally December 3rd next week. That is crazy. That is.
What day is the redetermination? Monday?
Tuesday, December 3rd, 9 o'clock.
Thank you.
Sure. Miss Marcia, in this one with Mr. Edwards, He cannot appear via Zoom, okay? Oh, okay, thank you, ma'am. Let me write this down. Hold on, DDC. All right, gentlemen at DDC, what's your name, sir?
Anthony Sturgis.
Burgess, sir, this magistrate out there, you're here on a criminal matter. Case number is 24058-71501, sir. You have an attorney. Go ahead, counsel.
Brad Marad, PA 3665. On behalf of Mr. Sturgis, we waive the reading. Mr. Sturgis stands mute. He's been advised of his rights.
Thank you. I'm going to enter a plea of not guilty. Court dates are December 5th, 2024. Probable cause conference followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Jefferson. Mr. Sturgis, you're not to possess any firearms or any other dangerous weapons, and you're not to have contact with Michelle Terrell. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You understand that, sir?
Yes.
Okay. All right. Counsel Ragland, give me your recommendation, please.
They're asking for $20,000 personal bond, Your Honor. Thank you.
No objection, Your Honor.
All right, $20,000 personal bond. That means nobody has to pay any money for you to get out of jail. Just obey all the bond conditions. Go to court when you have to. Thank you, sir. That concludes your arraignments. You can step aside.
I'm sorry, what was the PCC date one more time?
December 5th and December 12th.
Thank you.
What's your name, sir? Frederick Davis?
Yes.
Mr. Davis, I'm magistrate H. there. You're here on a criminal matter. You are defendant 3 in this case. Case number 24058911303, sir. You have an attorney. Go ahead, counsel.
Brad Marad, PA 3665. On behalf of Mr. Frederick Davis, we waive the reading. Mr. Davis stands mute. He's been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 13, 2024. And let's see who's this going to go in front of. It looks like Judge Jefferson. Okay. Sir, Mr. Davis, bond conditions. One is you're not to have contact with the Lorraine Williams. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You are not to go back to the Stringham Court residence. You understand those bond conditions?
Yes.
I will also indicate, let's see where it is, November 26, 2024, in front of Judge Jefferson. She issued a capias, $2,000, 10%, because he failed to appear for a prior court hearing. This court doesn't have the authority to modify a felony capias bond. Counsel Ragnan, you do not appear on a felony capias case, correct?
That's correct, Your Honor.
All right, Counsel Morad, do you have any new information?
No new information, just that one of the co-defendants' cases was dismissed at exam, but no authority from any judge.
Okay. Well, while this case is pending, the bond is $2,000, 10%. This court doesn't have the authority to modify the $2,000. Is this unaffordable, counsel?
It is, Your Honor. Mr. Davis, I think it has his hand raised. I think he has a question.
Go ahead, Mr. Davis.
I went to court, but they said I didn't have court. I got a GPS letter on. They said I had court on the 26th. I went up there and they said I did not have court. Then they put out a warrant for my arrest. And they came to my house yesterday and locked me up for no reason.
Well, Mr. Davis, you can give that all to your attorney. However, this court still does not have the authority, sir. So unless somebody pays $200 in this matter, what's going to happen is that you have another court date for Tuesday, December 3rd. So at 9 o'clock, you'll go in front of Judge McConaughey or Judge Williams will look at the bond amount and bond condition. That's if somebody doesn't pay the $200 for you to get out of jail. on this case. But if nobody pays it, then you go Tuesday. You understand that, Mr. Davis?
Yeah.
Thank you, sir. That concludes your matter. You can step aside.
Judge, that's an
What's your
unaffordable bond
name?
hearing December third.
Yes, it's unaffordable for this Tuesday, December 3rd, on Mr. Davis. And the gentleman at DDC, what's your name? Terrence Lamont, Jalan Blue.
Yes.
Sir, I'm Administrator Chuck Thayer. Your case number is 240-6067-201, sir. You have an attorney. Go ahead, counsel.
Ryan Marad, PA 3665, on behalf of Mr. Terrence Blue. We waive the reading. Mr. Blue stands mute. He's been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 5th, 2024. Probable cause conference followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Robbins. Mr. Blue, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, sir.
Okay. Council Ragland, CCW.
We're
Go ahead.
I'm gonna ask for a $50,000 personal bond. The reason for that is he is on federal parole and his probation officer has been contacted about this arrest. But we're just gonna ask for personal bond, but a higher personal bond. Thank you.
No objection to personal bond, Your Honor.
Okay, Mr. Blue, you're getting a $50,000 personal bond. Nobody has paying money for you to get out of jail. You can step aside. What's the dates again? December 5th and December 12th. Ms. Marcia. Thank you. The gentleman at DDC, what's your name, sir?
It is Deshaun Johnson.
Mr. Johnson, this is Magistrate Chuck Bass, sir. Sir, you have two cases. And they're the same court dates. So let me give you the first one. Case number is 2406078-101. Date of offense is November 21st, 2024. Carjacking, armed robbery, unlawfully driving away motor vehicle, felon in possession by prohibited person, 2 counts of weapons, felony firearm. Next case is 2406078-501. Date of offense is November 26th, 2024. Possession less than 25 grams of mission controlled substance. Asset amphetamine, hydrocodone. Receive it, police officer, assault to resisting obstructing, habitual third offense notice. Go ahead, counsel.
Ryan Marad, PA 3665, on behalf of Mr. Johnson. We waive the formal reading. Mr. Johnson stands mute. He's been advised of his rights.
I'm gonna enter plea of not guilty. Both cases have same court dates, December 6th, 2024, probable cause conference, followed by preliminary examination, December 13th, 2024. Both matters are in front of Judge Jefferson. Bond conditions on the carjacking case, sir, on that one is that you are not to possess any firearms or any other dangerous weapons. You're not to have any contact with a Jamal Farrell Jr. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. And on the drug case, you're not to possess any illegal controlled substances, and there is no assault or combative behavior on your part. Understand those bond conditions, Mr. Johnson?
Yes, ma'am. Understood.
Okay. Council Ragland, go ahead, Esteban, please.
Your Honor, the carjacking case and the armed robbery case, we're asking for a remand in that case. You certainly fit all the elements of armed robbery, pointing a gun directly at the person, car keys, and other items. On the controlled substance case, Your Honor, he has another one that is pending from November 7th for the same thing. So we're going to ask for a $25,000 cash surety bond on the drug case. Your Honor.
Okay. Council Marad, go ahead, please.
Judge, on behalf of Mr. Johnson, I'd advise that he's 27 years old. He's a life resident here in the state. He's been held since, I think Tuesday. He's been in there almost 3 days. He indicates, Judge, that he is working. It's a job Monday through Friday. He works the night shift, 10:45 PM to 7:15 AM. He also has another job that he works from 8 AM to 2 PM on certain days of the week. So he's working. Judge, he indicates that he's completed 2 years at Central State University. He does take some medication that he's not received. At this time, he's disputing the allegations contained within the investigator's report. He's maintaining his innocence, and indicates there are other circumstances surrounding that first case that's obviously not been brought to light yet. For all those reasons, I'm going to ask the court to consider reasonable bond or not, if not home confinement to a personal bond and home confinement on a GPS tether. I think the court can ensure all of its same concerns with that home confinement tether, Judge.
Thank you. Court's heard the representation of both sides, uses clear and convincing evidence standard when it's entertaining a monetary bond. We did start off with a personal bond basis. The court is looking at monetary bond or remand status. Remand status is no bond. Let's go off with both of these occurred within the month of November 21st and November 26th. One has the drugs and resisting obstructing. That has a little bit of assaultive behavior, or could be more that you can ask about flight. Let me make sure what I have here. Mr. Johnson was flight on the drug and assault to resisting. Okay, court is going to go with a $25,000 cash surety. Going to be placed on a GPS tether, house arrest. The court does find assaultive behavior, altercation with the police. Got him to a point that I believe it was more than one officer that took Mr. Johnson down. And that's going to be unaffordable, which is going to be correct, Counsel Counsel Morad?
Yes, Judge, any money is unaffordable.
Okay, so December 3rd, 2024, 9 o'clock this Tuesday, in front of Judge Mechanical, Judge Williams will look at the bond amount and bond conditions. Make sure that I that. Now, as to the other case, armed robbery and carjacking. Armed robbery is a charge under NCR 6.106. It is he charged with armed robbery charge, and he could be detained without any monetary bond if, court finds that his guilt is evident or presumption is great. This court does find, after reading the allegations in the investigator's report, that Mr. Johnson's guilt is evident, presumption is great. Not only that, I do believe he has another matter, but on that one, I believe that's non-assaultive. Is that correct, Counsel Ragnan?
It was a delivery case. The other one, same as the other delivery case where he got a $2,000, he failed to appear, he got a $2,000 10% bond, and then he posted. Non-assaultive. I'm sorry. Answer the question.
Yeah, I appreciate it. Thank you for that information. In this particular matter, this court does find Mr. Johnson to be a danger, not only to the complainant, but to the community, of carjacking, armed robbery. So he's going to be on a remand status. This case doesn't get a bond redetermination. That concludes your matter, Mr. Johnson. Sir, what's your name?
How you doing, ma'am? My name is Anthony Thomas.
Thank you, Mr. Thomas. Sir, this magistrate at Charter, you're here on criminal matter, case number 24060-78301, sir. You have an attorney. Go ahead, counsel.
Brad Marad, P 83665, on behalf of Mr. Anthony Thomas, we waive the formal reading. Mr. Thomas stands mute. He's been advised of his rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Sabri. Mr. Thomas, you have some bond conditions. One is you're not to have any contact with Brianna Watkins. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. You're not to go back to the Tyler residence, and you're not to possess any firearms or any other dangerous weapons. Understand all that, sir?
Yes, ma'am.
Thank you. While the charges are assaultive, this is from September 2023, more than a year ago. Council Ragland, give me your recommendation, please.
$25,000 personal bond, Your Honor.
No objection.
No contact.
No
Thank you.
objection.
Thank you, Mr. Wright. Mr. Thomas, you're getting a $25,000 personal bond. That means nobody has to pay any money for you to get out of jail. Please go to court. Please obey all your bond conditions. Otherwise, you're going to be looking at a monetary bond. Understand that, Mr. Thomas?
Yes, ma'am.
Good luck. You can step aside, sir.
Oh, geez.
What's your name, sir?
Howard Lee Aiden the fourth.
I'm sorry. What's your last name again?
Abram the fourth.
Abram. Okay, thank you, Mr. Abram. Howard Lee Abram, the fourth, sir, magistrate at there. Your case number is 240607841, sir. You have an attorney. Go ahead, counsel.
Brad Marad, P 83665, on behalf of Mr. Abram, we waive the reading. Mr. Abram stands mute. He's been advised of his rights.
I'm gonna enter a plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Robbins. Mr. Abram, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, ma'am.
Thank you. Counsel Ragland, give me your recommendation.
Your Honor, I apologize, but I'd like to know the charges if I could, please.
Sure, CCW, motor vehicle.
$10,000 personal bond. Thank you.
No objection.
Did you say how much?
10,000.
10,000?
Yes.
Thank you. All right, Mr. Abram, that means $10,000 personal bond. Nobody has to pay any money for you to get out of jail. You understand that, sir?
Yes, ma'am.
Go to court and obey your bond conditions, sir. Good luck. You can step aside.
Thank you.
Yeah, and I've had
You're
no
welcome.
chance. I could appreciate you telling me the charges. Thank you.
No problem.
Johnson Williams.
Is it Dante LeRae Williams, sir?
Yes, ma'am.
Mr. Williams, this is Magistrate Jeff Beck. Your case number is 240607861. You have an attorney. Go ahead, counsel.
Brad Marad, P 83665, on behalf of Mr. Williams, we waive the reading. Mr. Williams stands mute. He's been advised of his rights.
I'm gonna enter a plea of not guilty. Court dates are December 6th, 2024. It is a probable cause conference, followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Taylor. Mr. Williams, you have some bond conditions, sir. One is you're not to possess any firearms or any other dangerous weapons. You're not to possess any ammunition of any kind. You are not to have contact with these complaints. Dantes Hawkins and Dorian Moss. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Understand those bond conditions, sir?
Yes, ma'am.
Okay. Counsel Ragland, go ahead, Esteban, please.
Charge, Your Honor, please.
Charges, count one, weapons found possession by prohibited person. Count two, carrying concealed weapon, pistol on person. Counts 3 and 4, felonious assault, use of a handgun. Counts 5, 6. Count 7, weapons felony firearm. There's an habitual fourth offense notice. A 2010 felony firearm conviction. 2010 assault with intent to do great bodily harm, less than murder. Both of them are out of, let me see. Let's do one more. 2012 prisoner possessing weapons. That's out of Iona. County.
And people are gonna ask for a $60,000 cash surety bond, to be able to post a bond. We're gonna ask for a tether with home arrest. Thank you for the.
Go ahead, Council.
Your Honor, on behalf of Mr. Williams, I'd indicate that he's 31 years old. He's been in Michigan his whole life. He, does have the habitual offenders notice, but when you look at his priors, they're from 2010 and 2012. It seems that, there hasn't been any cases since then that I'm aware of, at least used on the complaint to habitualize him. He indicates that he's not pending bond. He's not on any sort of probation or parole. He's earned some trades, or 2 trades. He's completed some college. I read the investigator's report, and it indicates that there's no indication that these parties are related to each other, know each other. This seems to be an isolated offense of an allegation of some certain road rage. Subsequently, he was arrested and now he has to face charges. When it comes to bond, it doesn't seem that there's even a way of contacting the complaining witness here, as they're allegedly strangers. I don't think a complainant is actually at harm if Mr. Williams is able to go home. At the least, I'd ask the court to consider a GPS tether instead of a cash bond. He does have priors, but they're both over 10 years old. Other than that, no KPS history. I didn't hear him arraigned on any sort of traffic warrants. I'd ask you to give him a chance, Judge, and release him on personal bond. I wouldn't object to a GPS tether.
Thank you. Court's heard the representations from both sides. Uses clear and convincing evidence standard. Started off with a personal bond basis. What's concerning is allegedly is that Mr. Williams, he is blocking the entrance and exit of an employee parking lot. Allegedly, there's 3 complaints in this matter. The first complaint indicates that too scared to go back to work and doesn't want to go to court. So that leaves 2 other complaints in this matter. Yeah, these are all allegations. One of them says that Mr. Williams said, "I'm going to kill you." Allegedly, the gun was pointed at both complainants. And allegedly, Mr. Williams said, "Y'all think you're better than everybody else."
Again, Your Honor, despite those allegations, nothing's telling me that a GPS tether wouldn't be enough to make sure the integrity of the case and the complainants are preserved. They are strangers. He's not on bond for anything. He doesn't know who these people are. He can do no contact, and the GPS tether can ensure of that. Through the court rule, there is other means besides cash to impose bond here.
True. However, this is with strangers. If this is some indication that supposedly that there's a firearm and that he's going to harm individuals, if this was a road rage or whatever situation that it is, that makes this court believe more dangerous, not only to the complainants, but to the community at large.
And no one was in fact harmed.
Go ahead.
Sorry, I just wanted to add that, and it doesn't appear that there's an alleged injury. So like
No, I agree with you. There is no injury. There is no injury. Okay, but having a firearm that was found and the statements about harming, injuring another individual, that court does take seriously. So the court is going to adopt the recommendation, $60,000 cash surety. It may have been 65, but $60,000 cash surety. And we are going to place a GPS tether. Counsel, does he work?
No.
Okay, that would be house arrest. And I believe this is unaffordable. Is that correct, counsel?
Yes.
Okay, that means, Mr. Williams, you're gonna get another court date this Tuesday, 9 o'clock, in front of Judge McConaughey or Judge Williams, who will look at the bond amount and bond conditions. Do you understand that, sir?
Yes, ma'am.
Okay. So that concludes your arraignment.
Thank you, Your Honor.
Thank you.
Ivory James Pete Jr.
Hold on, sir. Okay. Ivory James Pete, sir. Good afternoon. This magistrate at there. Your case number, sir, is 240-607-8801. You have an attorney. Go ahead, counsel.
Brad Murad, PA 3665, on behalf of Mr. Pete, we waive the reading. On behalf of Mr. Pete, waive the reading, stand mute. Mr. Pete has been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court dates are December 6, 2024. Probable cause conference followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Giles. Mr. Pete, while this case is pending, you are not to possess any firearms or any other dangerous weapons. You're not to have contact with the complainant, Jose Santos. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Counsel Ragland, go with your recommendation.
Again, Your Honor, not having had a chance to read these.
Okay.
Ron,
The charges,
Mr.
November
Chair.
27, 2024, felonious assault, supposedly a green anti handgun. I don't believe anybody was injured from the investigator's report.
We'll just ask for $25,000 for.
No objection.
$25,000 personal?
Yes,
Okay. No objection, counsel?
No objection.
Okay. All right, Mr. Pete, this means, nobody has to pay any money for you to get out of jail. Just go to court and please obey all your bond conditions.
Okay.
Thank you. You can step aside.
All right, thank you.
Pardon me? Pardon me? Say what? I did. 25,000, I did. $25,000, court dates December 6th, December 13th. I did. Yes. I said the recommendation, and I said 25,000.
it's a.
We're gonna agree to disagree, Ms. Marcia. Yep. All right, the gentleman at DDC, what's your name?
Justin Michael Fremont, ma'am.
Freeland, Mr. Freeland. Justin Michael, sir, this is Magistrate Chavez. You hear a criminal matter, case number 240-607-9001, sir. You do have an attorney, sir. Go ahead, counsel.
Brad Murad, PA 3665, on behalf of Mr. Justin Freeland, we waive the reading. Mr. Freeland stands mute. He's been advised of his rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Giles. Mr. Freeland, some bond conditions. One, there's no assaultive or combative behavior on your part. You're not to possess any illegal controlled substances. You're not to possess any firearms or any other dangerous weapons. You're not to possess any ammunition of any kind. You understand those bond conditions, sir?
Yes, ma'am.
All right. Counsel Ragland, go ahead with your bond recommendation.
Again, Your Honor, could you read the charges?
You need the history? Okay, the charges, November 26, 2024. Possession with intent to deliver 50 grams or more, but less than 450 grams of a mixture controlled substance, cocaine. Count 2, weapons, fire, and possession by prohibited person. Count 3, carrying concealed weapon, pistol on person. Count 4, police officer, assault or resisting, obstructing. Counts 5 and 6, 7, each count is weapons, felony, firearm. There's an habitual fourth offense notice. 2015, drug conviction. 2017, drug conviction. 2019, tampering with evidence. And it's all out of Monroe County Circuit Court.
Yeah, the people be asking for a $40,000 cash surety bond. Post bond, we ask for a tether with some of it.
Okay. 40,000 cash surety, what?
Tether home arrest, see it, post bond.
Okay, thank you. Go ahead, Counsel Morad.
Judge, Mr. Freeland's 28 years old. He's a life resident here in the state. He lives with his mother and his 3 children. Your Honor, he does not have any cases pending against him right now. He works different hours at Tim Hortons. He does have priors, but his priors are all non-assaultive and from 2015, 17, and 19. So it looks like it's been at least 5 years since he's been convicted of anything. I read the investigator's report. The RNO charge is not assaultive. It's for, I believe, an alleged jerk away from the police officer. Nonetheless, there's nothing violent about this case whatsoever. It's not a danger to anybody. His liberties and freedoms should be preserved. I think jail should be held for the people that the court thinks is too dangerous to be out in the street. And Mr. Freeland's behavior contained in this investigator's report don't meet that. I think I'd ask the court for personal bond. If there was some sort of habeas history, I wouldn't object to tether, but I don't see one. I'd ask the court again to release Mr. Freeland on a personal bond, Your Honor.
Thank you. Court heard the representations, both sides. Use this clear and convincing evidence standard when it's entertaining a monetary bond. We did start off with a personal bond basis. I see that he has metropolitan ties. While some of the charges are not assaultive, there is in here where there was, Mr. Freeland allegedly is being given commands to stop. However, allegedly he's running away. And there is an altercation with Mr. Freeland and the police. A large amount of alleged narcotics is found, supposedly positive for cocaine, 126.3 grams. Okay. He does have prior convictions, firearm. Other than that, this court is going to place Mr. Freeland because firearm, running away from the police. While the narcotics could make him that he is a danger to the community, that he has in possession, not supposedly for personal stash, but possibly for trafficking. But we are going to give him a chance, and we're going to give him a $100,000 personal bond, but he is going to be placed on a GPS tether with work release, work only.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you.
What's the PCC date again?
December 6th.
Thank you.
Sure.
Dwayne Clark. Dwayne Emerson
I'm sorry,
Clark.
Croc.
Dwayne Emerson Clark.
Thank you, sir. Administrator Charte, your case number 2406078901, sir. You do have an attorney.
Rod Murad, PA 3665. I'm with Mr. Cochran. We waive the reading, stay mute. Mr. Cochran's been advised of his constitutional rights.
Thank you. Court's gonna enter a plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Taylor. Sir, while this case is pending, you are not to have combative or assaultive behavior while you're out on bond. Do you understand that, sir?
Yes, ma'am.
Okay. Council Ragnan, you need the charges read?
Yes, please.
Okay. Police officer assaulting, resisting, obstructing, November 27, 2024, habitual force, a drug conviction, 1991, 2000 CCW conviction, felon in possession, 2000. So far, okay, let me see, 2001, 2001, felon in possession, 2013, homicide manslaughter, 2013, felony firearm, 2013, drug conviction. And we have another one, 2013, drug conviction.
Well, Your Honor, the people would ask for a $50,000 personal bond based on his record and based on the assaultive behavior of the police, but just a personal bond, Your
Yeah, no objection, Judge. I agree with Mr. Ragnar's recommendation. It does, you know, it does seem when I read this report that when we talked to my client, that Officer Hasek, you know, heard it. He disputes some of it. He says he complied, but we are agreeable to the personal bond. That's all.
Court's gonna adopt the recommendation, $50,000 personal bond. Did you hear that, Ms. Marcia? No, $50,000 personal bond, just for you. Sir, you're gonna get a personal bond. Nobody has paying money for you to get out of jail. Do you understand that, sir?
Yes, ma'am.
Sir, just go to court. Please obey all the bond conditions. Good luck. You can step aside, sir.
Yes, ma'am, thank you.
Yes, sir. Sir, what's your name?
Rolling.
Bowen?
Yes, ma'am.
Bowen. Mr. Is it Corey Tomaine Bowen, sir?
Yes, senior.
All right. Sir, thank you. This is Magistrate Chartez, your criminal matter, case number 24060792001, sir. You have an attorney. Go ahead, counsel.
Brad Murad, P83665. On behalf of Mr. Boland, we waive the reading. Mr. Boland stands mute. He's been advised of his rights.
I'm gonna enter a plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, December 13, 2024. Both matters are in front of Judge Taylor. Mr. Boland, while this case is pending, you're not to possess any firearms of any kind or any ammunition of any kind. You understand those bond conditions?
Yes, ma'am.
Counselor Ragnan, do you need the charges read?
Yes, please.
This is from November 27, 2024, CCW, pistol on person, count 2, weapons fine, possession by prohibited person, count 3, weapons felony firearm, habitual fourth offense notice, 1996, attempt armed robbery conviction, 1996, armed robbery conviction, 2023, accessory after the fact. Those 3 convictions, please don't say anything, sir. Those 3 convictions are out of the state of Florida. 2023, tampering with physical evidence out of the state of Florida. And those are the only convictions, criminal convictions that there are, that I
Seems to
see.
me, he probably is on probation as well. in this situation. Don't know.
Maybe or maybe not, don't know.
Maybe not. So, all right. Well, we would ask for a $35,000 personal bond. He's a resident here now, I assume. I don't know, Mr. Murad.
No, we were actually going to ask for permission to travel. He was here visiting some family for Thanksgiving. He's got a wife and 3 kids in Virginia. He's been there, living there. He's working there as well. I know his first court date's on Zoom. Was going to ask for travel request if the court would consider that.
No objection.
$35,000 personal bond. However, where does he live, counsel?
He lives in Norfolk, Virginia, Your Honor, with his
Okay.
wife and their 2 children.
He's allowed to go to Virginia. Understand, sir, you can leave the state of Michigan to go to your domicile state, which is the state of Virginia. Okay, however, sir, if the court requires you to be in person, you need to come back. Do you understand that?
I do, yes, ma'am.
Okay, so $35,000 personal bond. Nobody has to pay any money for you to get out of jail. Understand that, sir?
I do, thank you, ma'am.
Okay.
Thank you.
Also, for the record, that he's very cooperative with the police.
Just like his lawyer.
Step aside, sir.
That's all I have right now from DDC. Your Honor, I need 1 moment to get some interview sheets.
Let's see.
I wouldn't know.
EDC.
Yeah.
EDC, do you have a Shantez Thomas?
That is me, Shantez Thomas.
Okay, that's you. Okay, thank you. All right, Mr. Deshaun Thomas?
Yes, ma'am.
Thank you, sir. This magistrate judge there, your case number is 240607911, sir. You have an attorney. Go ahead, counsel.
He stepped out for a minute.
Oh, he stepped out. Did he step out while I started the arraignment? If not, we'll go back. We'll do this again.
I think he's right there, just off to the side.
Okay, no problem. We'll start over again. Mr. Thomas, just stand by. Wait, let's wait for your attorney.
I'm here, Judge. I got his information.
Okay. Yep, let's go back. Mr. Thomas, please say your full name again.
Shantez Deshaun Thomas.
So your case number is 240607911, sir. You have an attorney. Go ahead, counsel.
Brad Murad, P83665, on behalf of Mr. Thomas, we waive the reading. Mr. Thomas stands mute. He's been advised of his rights.
I'm gonna enter a plea of not guilty. Court dates are December 6, 2024. Probable cause conference followed by a preliminary examination, December 13, 2024. Both matters are in front of Judge Sabri. Mr. Thomas, some bond conditions. One, you're not to have contact with Alexa Simmons. That means no person to person. Hold on. I'll make sure I have this correct. Alexa Sims. That means no person to person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go back to the liberal residence. Do you understand those bond conditions, sir?
Yes, she's
Now,
not one of them.
Mr. Thomas, listen to me. You have the right to speak, but understand, anything you say, okay, it can be used against you. Everything is being recorded. That's why you have an attorney to represent you. If you have questions about bond conditions, you have questions about the court dates, then raise your right hand. Do you understand all that?
Yes, ma'am.
Okay, and then if you still have any questions, you can still talk to your attorney. Do you understand that?
Yes, ma'am. I'm
Okay,
sorry.
so that's all right. Counsel Ragland, do you need the charges?
Yes, please, Your Honor.
This is from November 27, 2024, count 1, unlawful imprisonment. Count 2, assault with intent to do great bodily harm, unless murder or by strangulation. Count 3, knowingly assault, and battery of a pregnant individual. And count 4, domestic violence.
People are asking for 75,000 cash surety. If she's able to post that bond, we're asking for tether with house arrest.
Counsel Murad?
Judge, Mr. Thomas is 36 years old. He's a life resident here in the state. He has no pending matters against him, no probation, no parole. He's been in no trouble since 2008. Judge, he is a high-low driver. He works Monday through Saturday from 5 a.m. to 3:30 p.m. Judge, he's earned a GED. He suffers from diabetes and asthma. I had the chance to read through the investigator's report. Mr. Thomas is disputing the contents. I'd like to just bring the court's attention to observed injury. I think that's always the most telling with certain cases. And, an assault is described that's not really corroborated by anything. And then I think the only injury is a minor cut on the right palm. So, I don't really see how, we describe a vicious assault and the corroborating injury is a minor cut on the right palm. Nonetheless, he wants the court to know, and here's another thing, Judge. It says that she was held against her will for approximately 2 hours, eventually escaped and sought help at a neighbor's house. It's just not clear. What did she have to sneak out? Was he not there? He's disputing that this issue was ever that, or that this argument or whatever it was amounted to something physical, or let alone a situation where he had told her that she couldn't leave the house or where she wasn't able to leave the house. He's disputing that completely. And unfortunately, Judge, he's in the system now, he's here, he's charged, and it's up to you as to whether or not he's gonna get a chance to fight this case and put his position on the record eventually, outside of custody. And I think the court can do that. I think the court has tools like a GPS tether it can use. He has an alternative residence. They're not gonna be residing together while the case is pending. He's gonna stay with his sister. I don't see a reason why he can't keep his job, get a GPS tether to track him and to ensure no contact, and allow him to at least go to work only on this case pending, where I think the most vicious injury that's described here is a cut on the palm. So for those reasons, Judge, I'm asking for personal bond, GPS tether, work only, and I think that would be appropriate in this case.
Thank you. Court heard the representations, both sides. Started off with a personal bond basis, uses clear and convincing evidence standard when it's entertained in a monetary bond. Court heard the representations, both sides, in this particular matter from the investigator's report. This started as a verbal altercation in which the complaint refused to turn over her phone to the defendant, Mr. Thomas. Allegedly, he put his hand over her nose and mouth, pulled her hair, dragged her around the house, grabbed her by the neck, strangled her without her loss of consciousness. Basically, then she put over a pillow over her face, attempt to suffocate her. Allegedly, not only that, supposedly that she is 5 months pregnant. Okay, and yes, allegedly she sustained a cut on the right palm, reported stomach pain. She was transported to the hospital for medical treatment. Also, supposedly she left or escaped. The word says escape, sought help at a neighbor's house where the neighbor called 911. Okay. And Mr. Thomas was raising his hand. Council Murad.
Yes.
What you say, hold on, what you say is recorded, man, so I don't really want you to kind of get into what happened or didn't happen. If the magistrate today gives you a bond that's a money bond that you can't afford, we're gonna see a chief judge in 2 days and we can readjust this argument. But I really just don't want you to say anything or even admit to being in the situation. If this is a case that he no longer pursues, what you say right now, because he's in this case, gets bound over. So I really don't want you to say anything at all, okay?
Yes, sir.
Okay. Thank you. Court heard that. With that being said, he is going to be placed on a GPS tether, work only. The GPS tether is just for monitoring, tracking somebody. That doesn't prevent an individual who has a GPS tether from going and doing things that they're not supposed to be doing. So in this particular matter, this court does find Mr. Thomas as a danger, not only to Ms. Sims, but to the community, because Ms. Sims is part of the community. This court is going to adopt the recommendation of $75,000 cash surety. Okay. But however, as Council Murad said, okay, Mr. Thomas, you're going to get another court date Tuesday, December 3rd, 2024, 9 o'clock. In front of Judge McConaughey or Judge Williams, who will look at the bond amount and bond conditions. Do you understand that, sir?
Yes, ma'am.
Okay, thank you, sir. You can step aside.
Thank you, Anna.
I have to go and get sheets, Your Honor. I'll be back.
Okay.
May I take a moment also?
Go ahead.
That's all we need,
That's all there is. Oh, hold on. What happened to Luis Rodriguez Vera? Not at DDC?
He's not here.
Thank you. I'll see you on the female side.
All right. Judge, we're on the female camera right now.
Okay, go ahead and finish.
All right.
Council Murad?
Ready,
You
Your
guys
Honor.
ready? Young lady at DDC, hold on, ma'am. Let's go record. We are recording. Ma'am, what's your full name? Kathy Denise Lyons. Kathy Denise Lyons. Oh, Miss Lyons. Miss Lyons, this is Magistrate H.R. Thea, ma'am. You're here on a criminal matter. Case number. Hold on for a moment. I'm getting an echo. Say your name again, ma'am. Kathy Denise Lyons. Thank you, ma'am. I'm Magistrate H.R. Thea. Case number is 24060793001. The echo's low now. Go ahead, Council Murad.
Brad Murad, PA 3665. On behalf of Ms. Lyons, we waive the reading. Ms. Lyons stands mute. She's been advised of her rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are December 6, 2024, probable cause conference, followed by preliminary examination, 2024. Both matters are in front of Judge Giles. Okay, Ms. Lyons, while this case is pending, there is no driving of any automobiles, period. There is no drinking of any alcoholic beverages. And there's no assault or combative behavior on your part while this case is pending. Do you understand those bond conditions, ma'am? Yes, ma'am. Hold on. Ms. Garcia, do you need anything? Okay. 62755. All right. Council Ragland, go ahead, as the bond recommendation.
Well, yeah, $25,000 personal bond we're asking for in this matter. She has no priors that I'm aware of for drinking and driving. I think you covered it with no driving, no alcohol, so we want to ask for a tether.
No objection to the personal judge.
Okay. Bond in this case is gonna be $25,000 personal bond. Ms. Lyons, nobody has to pay any money for you to get out of jail. You understand that, ma'am? Yes. Okay, that concludes your arraignment, ma'am.
Come on.
Bye-bye. Bye-bye, ma'am.
Just a heads up, there's about 5 minutes left of this, and then I have to go as well because it is 20 past 10. So I'm sorry that I was MIA for a bit, and now I'm like, sorry, I gotta go. But it is day one of being back. So there's that.
Lions, 25,000. This is Lions. This goes with Lions. What's your name, ma'am? Brianna Bassett Hamill. Is it Brianna Ashley Bassett Hamill, ma'am? Yes, ma'am. Ma'am, this is Magistrate H.R. Thea, your case number 240607821, ma'am. You have an attorney, go ahead, counsel.
Brad Murad, PA 3665. On behalf of Ms. Brianna Bassett Hamill, we waive the reading. Ms. Hamill stands mute. She's been advised of her rights.
Thank you. I'm gonna enter a plea of not guilty. Court dates are December 5th, 2024, probable cause conference, followed by preliminary examination, December 12th, 2024. Both matters are in front of Judge Giles. Ms. Bassett Hamill, bond conditions. You're not to possess any firearms or any other dangerous weapons, including tasers, brass knuckles, machetes. You are not to have combative or assaultive behavior while this case is pending. Do you understand those bond conditions, ma'am? Yes, Your Honor. Also, let me see, November 27th, okay. There is no drinking of any alcoholic beverages. You're not to possess any, you're not to purchase any, you're not to sell any. Let me see what else. Go ahead, Counsel Ragnan.
People are asking for a $50,000 personal bond, Your Honor. We believe that having a taser and being in the problems that went through the investigator's report that she displayed, I think personal bond is appropriate. I don't think we need a tether in this case. Hopefully, this will be the end of it.
I'd ask the court to adopt the recommendation, Your Honor.
Court's gonna adopt the recommendation as recommended. $50,000 personal bond. Nobody has to pay any money for you to get out of jail. Understand that, ma'am? Can you say that again? I says nobody has to pay any money for you to get out of jail. Bond conditions are no drinking of alcoholic beverages, no firearms, other dangerous weapons, includes tasers, no assault or combative behavior. Understand that, Ms. Bassett Hamel? Yes, Your Honor. Thank you, ma'am. You can step aside.
Thank you.
Denise Marita Harris. Ms. Harris, this is Magistrate Attorney, case number 24046034001. You have an attorney. Go ahead, counsel.
Brad Murad, PA 3665, on behalf of Ms. Harris, who waived the reading, stand mute. Ms. Harris has been advised of her rights.
Thank you. I'm going to enter plea of not guilty. Court date is December 12th, 2024. Pre-trial in front of Judge Austin Garrett. Ms. Harris, while this case is pending, bond conditions, you're not to have any contact with Verde Wilson. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to go possess any firearms, dangerous weapons, and you're not to go back to the Archdale residence. Understand those bond conditions, ma'am?
Yes, packing my stuff to my stuff.
We get a
Yes, we're
one-time
gonna give
police
you a
escort.
one-time opportunity, ma'am, one-time opportunity with police escort to go to the address and get some of your belongings. Do you understand that?
Yes.
Thank you. Council Ragnan, recommendation?
We're asking for $25,000 personal bond, Your Honor. The bond restrictions, I think, cover any other potential problems. This incident has the defendant pushing a complainant in front of the police, pushing him down. $25,000 personal bond. Thank you.
No objection.
Ma'am, you're gonna get a $25,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that, ma'am?
Okay.
All right, that concludes the arraignment of Ms. Harris. CDC, I believe we finished with everything.
Okay, I told you that was the noisiest court ever. It is always like that, and actually sometimes worse. I enjoy watching Magistrate Burton, but a lot of the time I actually just have to put it into the archive to fix the audio and come back. Anyway, I'm going to say goodnight, and I'm going to send you over to American Courts. If you haven't been there before, don't forget to subscribe. Bill's just been remonetized again as well. And he's been a great support to this channel, so I appreciate it. If you will interact a bit, drop a message, say hi. I can't remember what we were saying, Mac Attack, Mac Raid, something like that. It's been so long. And I will see you ASAP, and emphasis on the P, because it might be very intermittent until I've had a little bit of rest. But I'll see you guys soon. Bye.